meeting, Board of Supervisors meeting of April 15th. Kaylee, can we have roll call, please?
Yes, Chair. Supervisor Arroyo? Here. Supervisor Madrone?
Present.
Supervisor Bohn?
Yep.
Supervisor Wilson?
Here.
Chair Bushnell?
Good morning again.
All are here.
Thank you. Can we salute our flag, please? We'll go to our CAO, Hayes. Are there any modifications to the agenda today?
Good morning, Chair Bushnell. There are no modifications this morning.
Okay, thank you. So we'll go on to our consent calendar. These matters are routine in nature and are usually approved by a combined single vote. Before we go into our consent calendar, my vice chair is going to say a few words.
Thanks. Seems to be my duty as vice chair. So today we have a long meeting, and it looks like there are some issues that people are going to be somewhat interested in and even somewhat passionate about. In general, we ask that participants and audience members keep any kind of cheering and booing to not just a bare minimum, but as quiet as possible. It's basically for the purposes of making sure that everybody who has an opinion on any subject feels welcome, that they feel like that, it can be intimidating to come up here even with nobody in this room, right? And so, so for some, we want to make sure that they feel like they can come up, say what they have to say, and so we don't have a lot of loud reaction around that. So waving hands in the air is customary, thumbs up, thumb downs, a little bit of stuff like that is fine. But if we can be as civil as possible, which we've all been here before, you guys have been civil before, so I'm not too concerned about it, but we customarily let everyone know when we have these kinds of meetings that this is sort of the way we go. We do make exceptions sometimes for retirements, and as I say, puppies and kids and stuff like that. So, there's some cheering, those sorts of things. But in general, as we all can respect one another as we move forward, and, to do what we can to make everybody feel welcome and have their opinions heard today. Thanks.
Thank you. So we'll go right into our consent calendar. Is there any board member who would like to speak on any item on the consent calendar? Okay, seeing none, we're going to go to public comment on the consent calendar. We'll start with Zoom.
Caller 7718, I will unmute you and you'll have 3 minutes.
Good morning. Good morning, Councilor. Can you hear me today?
Not very well. Can you speak up?
I wish to make a comment on D1 concerning the Board of Supervisors regarding the pay-based salary increase in 2025. I can understand this not being something that we can do. I strongly suggest that the county consider a incentive-based pay scale to go to save the family money and enable us to have more money to pay for salaries. I think that would be a wonderful thing. I do caution the union on a Me Too project kind of thing, or Me Too initiative, to basically balance the budget if that's what they want very quickly and easily. Go ahead and do it, but it goes up or down, and if the supervisor took a 10% pay cut, your cost to all of your pay schedule across the county would be down 10%. But sometimes it's be careful for what people ask for. Difficult times. I appreciate the fact that you made this clear to the union and the other people working there, where you stand on that one, rather than being strung on for months and months and months on things of that nature. So I did a number 7, I think, a hiring freeze exception. Again, I have a problem with some of those ongoing kind of things. I think number 4 was something I also wish to make a comment on. It's a ratified Economic Development Agency EDA grant agreement and amendment. it sounds like this is kind of one of those after-the-fact kind of things, which is unfortunately do, but I guess you have to do what you do. Thank you for the opportunity to make these comments on your consent calendar today.
Thank you. That is all, Chair.
Thank you. Is there any public comment in the room on the consent calendar? Good morning, Vernon.
Good morning, Madam Chair, distinguished members of the board, excuse me. I would like to speak on D1 also. I want to say thank you so much for the integrity and the trust that this is doing. All I can say is full integrity. Thank you.
Thank you, Vernon. Is there anyone else in the room? Public comment on the consent calendar? Okay, I'm going to close public comment and I'll come back to our board. Is there any member of this board that wishes to make a statement? Comments? No? Okay, I'll look for a motion, please.
Motion to approve consent calendar.
I'll second. Is it coming through? Motion carries 5-0.
Okay, thank you. Is Director Ford here? Oh, wait. We're going to go to public comment on non-agenda items first. And we'll start on the Zoom.
Caller 7718, I will unmute you and you'll have 3 minutes.
Moving right along here, I'm having a lot of problems understanding the human race. I don't approve of what Russia is doing in Ukraine. I have major concerns regarding what both sides of the human race are doing down in Gaza. I also have concerns about some major things that are happening in Humboldt County. And I will keep beating this drum where parents are inappropriately separated from their children. There seems to be kind of a, I guess you call it a God syndrome, and some people who are like to make decisions that have major effects. And they try and direct this from, and I do know squat about these things, Rex, try and direct these things from a personal agendas or personal opinions. And I have a problem with that. And it's an ongoing systemic problem we have in Humboldt County. We have the worst of ACEs scores. DHHS is totally failing the people because those say the worst there. If the job is being done, those would be improving rather than staying status quo, getting worse. I strongly support what the tribes are doing as far as trying to help their people. And I do think we really need to look at what's going on with child welfare services. Let's just be a critical eye. Some things will be brought to light in the near future. So times are changing. Politically, things are changing. I noticed today that the Nordic Aqua Farm appears to be on the ropes. They got their other one closed down. They're looking for funding. I don't see a segue for them to participate. As the same as I feel with offshore wind. I think both of those are doing about to do the same basket. So thank you for the opportunity to speak on non-consent items today.
Thank you. Caller 0150, I will unmute you and you will have 3 minutes. Caller 0150, I have unmuted you, but you can try *6.
Good morning. This is Dottie, and I'm from Southern Humboldt. And there's been some new information that I didn't realize that I just want to share with the Board of Supervisors. First of all, I want to thank Supervisor Bushnell for taking a minute to visit with me yesterday. It's very, very emotional and tense what's going on in Southern Humboldt about housing. But it's happening all over Humboldt County, not just in Southern Humboldt. There's a program, many of you know, I think, there's a program that the county has signed up for called HMIS. And that's a program where you're documenting people coming in, they're filling out a form, they're telling you what their needs are, what their experience has been, and it's a very confidential form that is filled out that is then used by the county and is used for grants along with, I think, reports to the state and federal government. So the HMIS program or form has to be filled out in order for a lot of the aid and assistance to come to people that are homeless. Unfortunately, there are two problems. One is one agency doesn't communicate to the other agency, so they don't know. Well, three problems. Another is that when a person goes into an office, tells them all their story and whatever, if the HMIS does not explain and qualify what they really need, then it just gets put on a back burner and they're not on it. Working with somebody that's near death, and he thought he was on this program for the last 15 years. Now, he's not a well man, he's not totally coherent, so that explains part of the confusion. But not being on an HMIS form means that he's not entitled to the extreme housing resources as we have in Humboldt County. So he's completely confused. Now the latest is the only way he can be on the HMIS form and get the help he needs is if he's in a tent. This man could probably not make it even 24 hours. So putting him in a tent is an outrageous idea. The Christian Science Church is the only homeless shelter in southern Humboldt all year long. And I don't mean this year, I mean last year and this year. We are doing it. We're not charging the county. And this man is scheduled to leave today. We told him he could be there for a certain period of time, believing that the county and the HMIS would pull through. And
Thank you for your comment. That is all, Chair.
Thank you. Is there any comment or public comment in the room on non-agenda items? No? Seeing none, I'm going to close public comment on non-agenda items, and we will go to our first public hearing, I think our only public hearing. So I wanted to give a little bit of a rundown how this will happen today. So this morning, we will open the public hearing and we will hear from staff, and then we will hear from the applicant. Then we will go to public comment, and then we will come back to the board. The board can ask questions of staff or of the applicant. So you'll have one chance to make public comment. There isn't a sign-up list, and so when I call for public comment, we'll go to Zoom first. Everybody in the room that wants to make public comment will line up and take your turn. You'll have 3 minutes, okay? So at this time, I'm going to go back to my agenda. I'm going to open the public hearing to consider revocation or modification of a conditional use permit granted to Kernan Construction for a rock aggregate processing and material storage and handling yard facility. So before I get started, I need to ask the board if there is any ex parte communication from anybody on this board. So I spoke with Praj, and I spoke with Ange, and I spoke to several folks in the room. I listened, did not make judgment or comment, and I think that's about it with my communications. Go ahead and say.
I talked with him.
Okay. All right, so then we will go to Director Ford.
Thank you, Chair Bushnell. Good morning. Good morning, members of the Board of Supervisors. John Ford, Joshua Doris, Cliff Johnson to present the Kernan revocation modification. Just want to cover something that has been discussed a lot about the jobs involved in Kernan. This is not a recommendation or a consideration. to at all remove the ability for Kernan to operate. This is not something that would result in the loss of jobs, to closing down the facility. And so I just really wanted to clarify that. At the last time this was brought forward, the recommendation was, and Mr. Doris will go into this in a moment, but the recommendation was to stop the use of the northern yard. We continued the item to explore other options. We couldn't come to an agreement, but are bringing back what we believe is an alternative that essentially takes the site back to what it should have been when it was originally permitted. And so it is not to revoke the entire use of the property. It is not to close down the operating plant. It is simply to bring the site into compliance or into alignment with the rules that were in effect at the time. If we could share a screen, we do have a presentation.
I got ex parte.
Okay, we're going to hold for 1 sec. Supervisor Madrone has ex parte.
Yeah, I met with staff on Friday to go over the staff report as well as some of the neighbors. So I believe that would also fit under ex parte communication.
Director Ford?
There we go.
Good morning, Supervisors. I'm Joshua. I'm going to give an overview on this project. Basically, it's a modification of the Kernan conditional use permit. Here's the location. The site's right here, and represented by the red star there up in Glendale area. And basically, in 2001, there's a CUP and a special permit approved for basically a heavy construction materials yard, and then also a special permit to do some wetland restoration along a creek that was basically degraded by prior activities of, log mills and so forth, and log handling decks, different industrial type uses. And here's outlined in red is the project site. Basically, the northern yard and the southern yard, they're referred to as. And here's the approved site plan. As you can see, I don't want to go into too much detail, but you can see there's a fair amount of items going on here. And then the complaints, the violation, and just in the summer of 2023, the county received a complaint that Kernan was operating 24 hours a day, 7 days a week for a few weeks. We investigated that, determined it was valid, and basically we wrote a letter to them saying you're basically violating, your conditional use permit, special permit, and we, tried to come to a consensus to arrive at a resolution. We held routine meetings with the staff in Kernan throughout 2024, and then in later 2024, there's complaints received about grading in the northern yard, basically unpermitted. And then also in October 24, the department issued a notice of violation of their CUP for basically doing work without permits.
Notice of violation.
Pardon me, not a notice of violation, but potential of non-compliance with their CUP activities leading to that. I don't want to, violations not appropriate here, so excuse me. For basically some grading and then riparian vegetation removed as well. And then so here's a breakdown of the unpermitted activities in the northern yard. Basically there's a stormwater detention basin constructed without permits, and then also a berm constructed along the eastern side of the northern yard to redirect storm flow from Noisy Creek to basically channel it appropriately south through the site. And then also there's removal of riparian vegetation that was designated as being retained on the site plan, so some of that was removed as well. And here's an overview of the highlighted yellow. That's the detention pond. That was, thank you, John. That was created without permits. And then over to this side, here's the berm. Comes along this area here. That was also created without permits to redirect the flow. And then here's looking east over in the floods of, the early floods of 2024. There's a view looking east over the yard. Here's the, let me see here. Right there, that's a stormwater detention basin that was, constructed without permits. Essentially, it was, like I was saying, constructed without permits. And then looking in the far up along the top is Glendale Drive there. And then just west of that would be where the berm is constructed. It's hard to see through this imagery, but basically to redirect the flow. And then this is just an example again of the flooding that occurred and the magnitude of it, just for your perspective. And then here's, we wanted to quote the Humboldt County Code allows, use permits to be, basically be modified, according to under these criteria. And we believe that it's become, is operated to become a public nuisance, basically because, I'll go into that in a second. And that's our approach there. Basically feel it's been granted and be conducted as a nuisance. Oops. And then our original recommendation, as John alluded to in December, there was a recommendation to revoke the use of the northern yard, but then we decided to pull that from the table and kind of come to a dialogue and try to come to a consensus, try to come to a path forward, a resolution. And the meeting was ultimately continued to today. And then Kernan, there was a couple proposed solutions. One was the replacement of the Noisy Creek culverts, because that potentially is a cause of the flooding, but that's complicated with public monies and private monies mingling. It's a little just too complex to just say, well, we'll upgrade the culverts and be done with it. So it's being in public road, it's a little more tricky than that. And then also, Kernan submitted a buffer enhancement and vegetation plan, basically proposing to retain the berm in its current location. And it's close to as 8 feet from the channel edge of Noisy Creek, which I want to note is actually a violation of the SMA at the time, which is 25 feet at the time, and it's, it doesn't meet that standard at the time of approval. And then our staff's analysis of the vegetation and revegetation plan was the berm doesn't provide suitable habitat for protection of fish and other amphibians. It's a fish-bearing stream. There's also been some asphalt in the creek, basically chunks of asphalt just discarded into the creek. And then we're recommending a compromise of a 25-foot setback of the berm from the riparian drip line, which we're recognizing historic and the current SMA, trying to arrive at an agreement. And then also there's a road in that area as well, and we're proposing to relocate that further west outside of the SMA as well. And then our current recommendations are to modify the CUP. There are also conditions of approval in the staff report, but basically to obtain a survey along the property line because it's unclear exactly where the property lines are, and then basically to relocate the berm to outside of the SMA, reestablish veg between that berm and the SMA, remediate the creek, and then again relocate that road outside of the SMA, and then also clarify set hours for hours of operation and noise limitations. And then a little background on our justification for the hours of operation. The approved CUP listed those hours there, but it was not a condition of approval. It was a little vague. It was in their project description. But then we determined that those hours of operation had to do with rock crushing and other heavy activities. So it just spoke to that and not to other aspects of the business. So we believe that needs a little clarification. And then right below that is our justification for that, our proposal, basically to ensure there's no additional adverse impacts. We're proposing to limit all hours of operation to those that you see listed there. And then also on our proposed condition for noise, as I said, the approved CUP shall not exceed 60 LDN at nearby residentials, which that's a noise averaging. It basically collects noise during the day, and then you average it over 24 hours, you got another 10 decibels at night, and then that's how you get the decibel reading. So it's not truly representative of the noise during the daytime. And then, as we stated there, one of the offending sources of noise is backup beepers that are required for occupational safety, and we understand that. And we would propose to modify the noise, implement a restriction that shall not exceed 70 decibels at the nearby residential properties, or this last bullet's not in the conditions, but we thought it's just another possibility, basically require the backup beepers to be backup squawkers or a little more quieter. That's just something for the board to consider. And here's our recommended actions as well that are also outlined in your staff report. So if you have any questions, we'd be glad to answer those.
Is there any more to the staff report?
That completes the staff report.
Okay, so I'm gonna go, do you have a clarifying question? I'm gonna go to the applicant next.
Yeah, I do.
Okay, clarifying questions, please.
On the setback, did the berm, that looked like a 50-year flood? It was a 50-year flood? The picture you showed where the retention pond and
Yes.
everything? Was there any failures or anything? Is the berm's been there a while. Did the berm work where it was at?
The berm remained in place, yes.
Okay. Will it cause more harm to move it?
We're gonna just ask clarifying questions if you would, and
It
then,
was.
The pond, the berm that created the pond was there, did not fail. The berm that we're talking about now along Glendale and along Noisy Creek was not there at that time.
Okay, that was,
thank you.
thank you. And then the other thing on will OSHA approve the quieter beepers in a industrial construction zone?
This
Because
has
they're all
been,
wearing they're wearing hearing protection already, unless you've been in an accident where somebody's been hit. It sounds good. It sounds fuzzy, but I'm not sure if it'll work. I was in favor of it, but then I've heard from.
so I don't have firsthand knowledge with respect to OSHA. I do believe that some of the vehicles have been equipped with alternative backup beepers. So I'm presuming that passed the test from the safety officer at the site.
Supervisor Arroyo?
Thank you. I was curious when looking at the initial conditions of approval about how LDN, the day-night average sound level, is calculated, and you spoke to that a bit, but has that analysis been done, or are you saying that that's it's a hard analysis to do, or what's the thing there?
Well, it needs technically like a sound engineer, but yeah, North Point Consulting conducted a couple 24-hour sound measurements, and those came in under that threshold.
Okay. All right. Thank you.
Supervisor Wilson?
Thanks. These are just clarifying for me. The berm that you said was not constructed in a way that was took into account the environmental conditions. Was that the berm of the new berm that you're talking about, or was that of the stormwater basin that was along the creek there?
That's the new berm. The
Okay.
original berm, this gets a little confusing.
Yeah,
But
thank
when the original special permit was granted to allow filling of wetlands, there was a berm constructed along the south side of Hall Creek.
Right.
That retention pond was built outside of that berm, so we consider that to not be a violation of the SMA.
Okay. Thank you. That was perfect clarification. But the 25-foot or the 25-foot setback is for the new berm area or the old berm area?
It's for only the new berm area that was
Okay.
recently constructed, and only along that portion that's along Noisy Creek.
Okay. And a mitigation that was proposed was the culvert construction, but it was found to be just too complicated. And could you just give me just the briefest
Sure.
summary of why that was too complicated?
So basically what Scott Foley offered to do was to put in the berm or put in the culvert under Glendale Avenue for Noisy Creek for $500,000. We were throwing around a lot of figures. But when we started realizing that, okay, that is government money going towards a government facility, and it's going to cost a lot more than that, then we're starting to mix together all kinds of government money, and then it has to be prevailing wage. And then there's discussion about who designs it and how does it get designed and what level does it get built to. And it just became very, very complicated to get there.
Okay, when the new berm, after it was built, there was a storm event where it redirected stormwater, right? Is that what happened?
Yes.
Was there any do we know of any adverse impact of that redirection of the stormwater?
We haven't had any reports of flooding of property or the inability to pass on Glendale.
Okay. And then the new berm, I'll just call it new, old, whatever, that was built without permit, and we don't, do we know if it was engineered in any way?
It was built without permits. They do have an engineered plan in for an as-built plan that we're reviewing.
An as-built, but not a pre-built engineered plan. Okay. And then going back to the stormwater pond, that was built inside what was considered the old, the old berm along the creek there. And so was that also built with a permit or without?
That was built without permits.
And then that was built without permits. Was it also had no engineered plans that we know of, or
they've submitted as-built plans for that. We did not have pre-engineered plans for that.
Okay, so has there been any confirmation of the construction materials used for, what's inside the berm or how it was built?
We're currently reviewing that as part of the grading permit.
That's I think there was concern or discussion around noise associated with maintenance of equipment.
Yeah.
And so how's that, how was that where was that in your presentation?
So, yeah, and I'm going to go back a little bit to clarify what could be very confusing, is that the original operations plan indicated hours of operation for the rock crushing facilities. Mm-hmm. In the operations plan that was submitted by the applicant at that time, it did not address any other hours of operation.
I see.
But in the staff report, in the title of the staff report, it indicated that there were limitations on the hours of operation.
I see.
And so we started off from the presumption that that was something that was actually included with an operations plan, that was something that was offered, but now it's been clarified by the operator that that was never their intent. They didn't put it there. Nobody knows how that got there. And so I don't know if that was something that in 2002 staff put in there thinking that that was important and didn't condition it, or if there was some agreement that happened before then and it was added in, but it was not put in as a condition, so it can't be treated as binding.
Okay, but we're kind of in it.
So now we're moving forward.
Yeah.
And realizing there really is no hours of operation on the site. And so one of the things that has been a complaint is that in order for the operator to be able to have their equipment ready during the day, they work on the equipment at night in a large kind of a Quonset hut-looking facility. And the neighbors have complained about that. Initially, we thought that that was out of compliance with that provision in the project description. Now we know it's not. So the question that we're presenting and proposing is that the hours be limited, or at least figure out some way to minimize the nighttime noise so that it's not something that the neighbors hear all the time. It's noisy out there during the day, in fairness, and it's not all from Kernan.
Right.
I mean, that area is active.
Okay, so we're looking at possible mitigation as part of the package here, and I'm talking about nighttime noise mitigation.
Right.
Whether it's hours or some other physical modification or something like that.
I mean, we've talked about a lot of things, even from, it's like if you're going to work on vehicles inside the building, can you just shut the door?
Right. Okay, that ends all my questions. Thank you.
Supervisor Madrone, and then we're going to go to Supervisor Bohn again.
Thank you, Chair. Could we pull up that picture of the site that was flooded? Yeah, thank you. Appreciate that. I know there's been a lot of talk about whether or not this is in the floodplain or not, and I know Angie actually worked with FEMA, I believe it was, to actually identify the floodplain in that area. And technically, I believe the vast majority of that area is not in the 100-year floodplain based on the FEMA mapping. But would you say that's flooded right there now in that picture? The area is flooded?
Well, I think it's pretty clear that you can see that the area south of the access road there is clearly flooded. That's a separate piece of property.
That's the Christie Fields?
Yes. You can see that it's hard to see, but Glendale Boulevard is up here. So this is part of the operational area. And if it's not flooded, there's a lot of puddles there.
Yeah, it looks like in the area above Glendale Drive, it's all flooded up in there as well.
Correct.
Yeah. Anyway, the whole area is very low, and there was a lot of documentation of a lot of sediment leaving the site during this event. This was the January event, 2024, I believe, the big high water, where we got 4 to 6 inches of rain in 24 hours. And there is a lot of documentation that while the retention basin did not fail, the pumps that were trying to pump water from areas that were going to deliver sediment to Hall Creek there on the left, or Noisy Creek up at the top of the picture, they were overwhelmed. And the pumps couldn't keep up with the flows, and that there was sediment delivery. That was documented by the Water Board and others during these events and afterwards. So I think that is a big concern. Now, just to be clear, we're not seeking revocation of the permit at this time. Is that correct?
That is correct.
Okay. We're simply trying to get the operator to adhere to existing conditions in the permits that were violated, and also to add potentially other conditions to try and improve the operations. Is that correct?
Well, if I could clarify that a little bit.
Please.
I can't say that they were violating the condition of approval relative to noise, because the one operative condition was the LDN standard, and information was given to us that showed that they were in compliance with that. We do believe that there's a lack of clarity on where the SMA should have been respected, and that's one of the things that we're trying to define right now. The one area where there probably was an ongoing violation but really wasn't discovered until this incident related to the documenting where the material came from, the stockpile material, and doing the soil testing within that. So I think that's really where it is. Then when we start to talk about noise, and Mr. Doris put this up on the screen, It really comes down to whether or not the noise that's being generated by this site, either during the day and or at night, rise to the level of being a nuisance, and whether that requires adding an additional condition.
Okay, appreciate that. So, yeah, and you also mentioned that there's noise coming from other sources in the valley there. Would you say that the conditions in this valley have changed in regards to the residency and the community there? I mean, 20, 30 years ago, almost everybody that lived in Glendale worked at one of the mills, one way or another, for the most part. Almost every family, you know, got their employment, their income from working either at these mills or out at Corbell. And over time, that has changed and has become a residential community along with commercial and industrial. And would you say that that change can potentially lead to conflict, and it requires both parties, residences as well as industrial operators, to really kind of consider that and work towards being considerate of each other? I mean, for instance, the residences need to understand this has been there a long time, these operations, correct? I mean, but those conditions have kind of changed in terms of why we're seeing some conflict now.
Well, that's a hard one to address, frankly, from a land use standpoint, because the industrial zoning or pre-existing use has always been there.
Yeah.
I mean, so that has not changed.
Right.
And this particular site has not ceased use. Some of the other sites have been used, not used, used, not used. That's not the case with this site.
Mm-hmm.
I think one of the things that perhaps has occurred here, and in some respects this is a good thing, is the site has more activity because there's more demand for the materials, and so there's more trucks and more activity going on. But in terms of it being an industrial site, that has not changed. There are additional residences across Glendale Drive. There's no doubt about that. And that's a change, but that's one of, and there is a conflict often between industrial sites and residential uses, and the expectation of what, you know, residences expect. There's often complaints. That you hear the complaints right now about the 737s going into Arcata Airport because those are louder. But many people would find that to be a good thing.
Right. Okay, thank you. That's all I have.
Supervisor Bohn?
Yeah, that's, because actually I would venture to say, and I'd say I'd probably have a pretty good idea, it's a lot quieter out there without McNamara Peep and Blue Lake Forest running 24/7. And their log yard at Blue Lake McNamara went back quite a ways. So, and they operated 24/7 blue chip milling, making 60-inch logs into chips for the Pacific Rim and Columbia River. They have done a lot out there. And then other things I see where we've got the berm is the berm. You just said it was working, and I guess there's documentation about the run.
The berm was not in place.
Understood, but the retention pond.
The retention pond, right?
And
yeah.
you can see that by the flooding, you know, from the Christie Field. The water is coming from the Christie Field, but it's not getting on to this property. But what I want to go back to is the part where we're adjusting, and this has always been an industrial parcel. And you said at the December 3rd meeting that the meeting was not, before we extended it, you mentioned that this was not about noise or hours of operation.
I didn't say that. I said that it wasn't a violation.
Okay. That was not a violation.
Yeah.
But are we, so if it's not a violation, because my problem is we have SB1 monies, we have our road monies, we have a lot of monies coming in to fix our roads and our infrastructure. And my issue is a lot of these jobs require nighttime operations. So that would take a point where someone can't, if they can't do nighttime operations, that's going to create a problem. And you made the great analogy about the airports and the 737s. I'm going to buy a house. It's discounted because it's next to the airport, and then I'm going to stop at the airport. So these are the things that are kind of concerning me, knowing that there's less noise than there was. We're talking about people that have moved in and now decided that they don't like it. And that's not all of them. A lot of them have lived there a long time. A lot of them have moved in, and a lot of them have retired. Now they're home all day listening to the noise, which can be an issue. And I know it's an issue. But my concern for Kernan is true, but my concern is I got 20 emails yesterday about the asphalt plant out on Hatchery Road. I mean, is there blood in the water? Are we going to go after every industrial site we can now to shut them down? I'm not saying they're good, bad, or indifferent, but how do we operate without these things? And you said this wouldn't cost jobs. If you take away the nighttime operations, there's going to be there's going to be mechanics, lubrication guys, and everything else, because they're going to have to cut down their operations. So there will be a loss. Will it be a great loss? No, Caltrans doesn't have a lot of 24/7 jobs, but they have them. So, thank you.
So I know Supervisor Arroyo, but I really want to give the applicant an opportunity, so please just clarifying questions. Thank you.
Thank you. I'll ask a question that I'd like to hear from staff, and then would also like to hear from the applicant, your thoughts on this. So we do have a set of proposed conditions of approval, revised conditions of approval here in the agenda package. And I just want to hear from staff, and then of course I want to hear from the applicant when it's their turn to talk. Do you think that this is responsive to the concerns you've heard from neighbors, from CDFW, as well as the applicant? Do you think this is a middle ground that you've recommended here that you can, fully support today?
So I'm going to answer that in two parts.
Okay.
In response to the relocation of the berm, I think it is responsive to the concerns that we've heard from CDFW. We've coordinated with CDFW. It's based upon conversations with them. So that's, and we believe it's a reasonable compromise to what's been done. In terms of the noise, this is a little bit more touchy. We're trying to find a balance because we don't, frankly, I don't think staff wants to see them have to shut down at night completely. But we'd ask for them to give us a proposal. How can we balance this a little bit and address some of the neighbors' concerns? We haven't gotten a proposal. So this is our effort to come out and have a dialogue about what can be done to realistically try to address some of the noise concerns that exist out there. It's never going to be a completely pastoral setting that's very rural and very quiet, because this is an industrial site. But can we take some of the edge off is really what we're trying to accomplish.
Okay, and so that's the part that you haven't gotten a proposal from the applicant about.
Right.
I'd love to hear more about that in a moment. And then was 70 decibels chosen because exposure to over that is related to hearing loss, or how did you determine 70 decibels?
It comes out of the general plan.
Okay, okay,
Yep.
helpful, thank you.
So we're going to go to the applicant, but I have two questions. So the 7 to 6 p.m. is for the rock crushing portion?
No, I think we intended that to be for all activity.
So when you were doing your presentation, you said that there was a 7 a.m. to 6 p.m. current time frame for the rock crushing.
Originally, that was for the rock crushing. That is correct.
So that's what the hours of service for the rock crushing are currently?
Correct.
And no hours of service for the full yard?
Correct.
And when, Joshua, when you said that there were, you went out and there was activity after the hours of service, was that reflective to the rock crushing plant?
No rock crushing after hours, no.
So then when you said that there appeared to be activity outside of the permit, that wasn't an accurate statement?
That gets back to when we were reading the project description
Yes.
to include limitations on hours of operation.
Yes.
We were interpreting that, understanding that to relate to the entire operation. There was no actual, we've evolved in our understanding. We now know that that's not a violation, that our original understanding was that was a violation because it was in the project description. But upon further analysis, going back and looking at their operations plan, that was not proposed by them, and it was not conditioned by the county. So we've backed away from that. So I just, in 2023, there was rock crushing 24 hours a day.
Okay. Okay, I'm going to hold the rest of my comments until later. So who, are you going to be speaking for the applicant? Yes, is this on? There's a button on the neck.
That one does not work.
So you can share. Yeah, you'll have to share.
Okay, can we hear me now?
Yeah, and so normally the applicant gets 15 minutes, and so you'll have the 15 minutes, and then the board will have an opportunity to ask you questions, which is not a timed, we're not going to, we're going to let you do your thing, but so we're going to set the clock for 15 minutes and just try to work within that.
With all due respect, we did ask before the last hearing for, I think, 20 minutes, given that this is an evidentiary hearing here. So we've prepared some significant technical data that Dr. Dodd and Praj White are going to be going through.
Well, the last hearing had a different chair, so I didn't get that communication. I'm going to go ahead and allow you 20 minutes.
Okay, thank you. That's very much appreciated. We have a PowerPoint. Is it possible to?
Yeah, Kaylee will get your PowerPoint up.
Okay, and then can we pause the clock until that's done?
Go ahead, Rex.
In the meantime, I'll just introduce myself. My name is Brad Johnson. I'm a land use, environmental, mining attorney. I'll be representing Kernan today, talking through some of the legal aspects and then some of the evidentiary aspects of the hearing in front of you. And then to my right is Praj White with North Point Consulting Group, and then to his right is Dr. Angie Dodd with North Point Consulting Group, and they'll be talking through the technical aspects that are involved here. So that's how we'll be proceeding.
So I would ask my board that let them have their 20 minutes, and then if there are questions, so that they don't use up their clock, that those questions come after their presentation, please.
Could I just ask that you hold the mic really close?
Sure,
Thank you.
definitely. I'll hold it close, and I'm also going to speak quickly because I'm going to get through my part, which is probably the least important part here. So,
Chair, it is ready.
Okay, go ahead.
okay, great, thank you. So, this is how we're going to proceed today. Kernan Construction, I won't spend time on this. They're a long-standing corporate citizen of this community, employing 100 people full-time, more or less. Anticipated payroll for 2025 will be $8 to $9 million, and almost all of that money stays in the community because these are people that live and work here. So that's who Kernan is. They are engineering, contracting, construction firm. They do work often at night, not just for Caltrans, but for other public projects and also for serving private industrial businesses in the community. So working off hours is not just about Caltrans here. I did want to also circle back to something that staff said to begin. The reason that we're here right now is because staff issued a notice of revocation proceeding on October 24th. That's why we're here. This proceeding has always been billed as a potential to revoke this use permit, and as a result of that, Kernan has expended hundreds of thousands of dollars in responding to the allegations that staff have put forward. So to say now that that's not at risk, I think kind of belittles both this process and I think the stress, both kind of existential and economic, that this proceeding has put Kernan through. So I want everyone to be aware that that is still what this proceeding is. It's a permit revocation proceeding. Yes, the county may modify the permit, but that's an option, and so is revocation. So I don't want to take away from the gravity of this hearing. Going to that, so this is an important hearing, and one thing that the board has not heard is what the legal rules are. It's a bit like being asked to referee a sports game without being told what sport it is or what the rules are. You're being set up to make bad calls, and the problem is if you make a bad call here, that can be unlawful, and that can also expose the county to some serious liability. So it's important to understand what's going on with this proceeding. This use permit that we're talking about is not just a any use permit. It is a fundamentally vested use permit. It's a use permit that Kernan has expended millions of dollars in furtherance of and has operated pursuant to for more than 24 years. So that is what's known as a fundamental vested right. The county cannot revoke this use permit without notice of fair and impartial hearing. And there are specific standards that apply to what an impartial hearing is, and a valid evidentiary basis based on substantial evidence. It's not just complaints. And I want the board to take that to heart. Complaints may be evidence if they're substantiated, but this is a circumstance where there are neighbors that have said publicly that their goal is to put this business out of business. So the board must take those complaints in that light and look at the evidence on whether or not it is actually substantial or not. Because this is a vested use permit, Kernan is afforded full due process rights. That means opportunity to be heard, fair and impartial hearing body or officer. There's actually case law that says that the county's council, actually the same council, cannot both advise the board and present the case on this hearing. Because of that, that's a violation of due process rights. The action must be based on substantial evidence. Substantial evidence is not conjecture or speculation. It is real evidence of legal preponderance. There must be no other reasonable way to correct the condition, finally. So that means that before you revoke a use permit or impose significantly restricting conditions, you have to find a reasonable way to correct the actual conditions that's been cited. Okay, so let's look at the county process here. So here's County Code Section 312.14.2. As staff said, they have alleged that the permit is being exercised contrary to the terms or conditions of the approval. They've also alleged that Kernan is exercising the permit so as to be a nuisance. So equal protection. So when we're talking about conducting in violation of any law, that first standard here, that's a very broad standard. So what we have to pay attention to is how has the county enforced and utilized these provisions in the past. We've asked the county for documents evidencing other cases where the county is asked to revoke a use permit for grading violations, and there are none. So this would be the first. Why is it happening here? Secondly, nuisance, also very broad. Anything dangerous or detrimental to public health or safety, violations of law. Public nuisance is something that affects a broader segment of the community. But again, nuisance has to be proven by substantial evidence, meeting the actual legal definition of nuisance. So when we say nuisance, that is a legal term of art. It isn't just I'm standing on my porch and I can hear a backup beeper. That is not a nuisance. Issues before the board today. So really this is narrowed down to, was Kernan required to obtain a grading permit before constructing its advanced stormwater berms, the retention pond? And if so, does that constitute grounds for revoking or modifying the use permit? Issues not before the board. Hours of operation. Director Ford on December 3rd said the hours of operation, we do not consider at this point in violation of the permit. The hours of operation, we are not bringing that forward as a violation of the CUP. There is no substantial evidence in the record that Kernan has operated in violation of the permit's terms and the operating hours that are set forth in the permit. So we can clarify that. We can talk through the exact language with the board when we have a moment to ask questions. Moving on to the next one, noise. No allegations in staff report that Kernan has violated a noise condition. This is a substantial evidence hearing. There is no discussion in the staff report regarding the only substantial evidence on this issue, which is this noise report that North Point submitted to the county showing, using the LDN standard, the CNL standard, that Kernan was operating within the existing noise limitations in the permit. There's no other evidence showing that they have operated outside of that condition. And I would caution the board, the condition that the staff is proposing, 70 dBA, my voice right now is outside of the permit reaching 70 dBA on this noise meter here. Okay, so I want you to understand that that is a momentary measurement that staff is saying that somebody with an iPhone walking by can use to say, oh, Kernan's operating outside of its noise limitations. Now, you talked about the asphalt plant. Imagine setting that precedent for every industrial business throughout the county. That is a huge mistake, huge mistake. Soil sampling. There is no requirement in the use permit that we actually submit a sampling plan. That doesn't exist, and we can go through exact language if we need to. It's in a letter I submitted yesterday. The sampling plan beyond that already exists in the operations plan that was reviewed and approved by staff in 2001. There's already a sampling plan there. Furthermore, staff has never asked for anything more on this issue in the last 24 years, so it's hard for me to believe that it's all of a sudden an issue. There's no requirement that we submit soil tests either. That's not in the use permit. And the only time that we have submitted, which we did in response to staff requests, the sampling showed that the material is clean. Other things not before the board, CATS lawsuit. Okay, this is a lawsuit that was settled. This is a Clean Water Act lawsuit, which is like the ambulance chasing type of lawsuit of the environmental world. People settle it because there's huge risks if you don't settle them. So current settled, there's no admission of any violation. Neighbors have filed more lawsuits. That's not before the board. Those lawsuits don't mean anything. Regional Water Board. So this was something that staff had mentioned in December. Staff did not mention that the Regional Water Board has since withdrawn that NOV, finding no violation. That's not before the board. Lastly, California Department of Fish and Wildlife, no violations issued from CDFW. We found out just on Thursday of this past week that CDFW had sent an email to staff last March asking for some things related to berm and revegetation. Staff didn't forward that to us, but it's not a violation. Staff, CDFW wants to see more revegetation. Point to me somewhere where CDFW doesn't want to see more revegetation. Okay, so I'm done. I'm going to turn it over to Dr. Dodd. Dr. Dodd is going to spend a few minutes talking more about this noise and the difference between DBA, LDN, CNL standards, and why what staff is recommending is totally out of the pale.
Please pass. Yeah, thank you.
And I'm going to talk quickly since we're limited, and then if you have any questions after, we can always go back. So in August of 2024, we submitted a detailed noise study demonstrating that Kernan was operating within their use permit. So the use permit is not exceed the 60 LDN, which we've discussed. The LDN is a 24-hour average with a penalty at night. You add 10 decibels to the noise gauge readings at night from 10 p.m. to 7 a.m. So it does take into account an adjustment for when it's quieter at night. We did multiple days at the nearest property lines at both yards. Those were the times. These are the locations in the upper yard and the lower yard that the meter was left for a long period of time. Excuse me. We analyzed the data, and the LDN for all these was well below 60 decibels. In addition, this was all presented to the county in a Stanford engineering report. In addition, we looked at this time we thought there were operational hours. This has further been clarified in the operations plan that operational hours specifically related to rock crushing. I wanted to point out in 2023, the 24-hour activities were not associated with rock crushing. It was associated with moving dirt in the lower yard for a 24-hour Caltrans project. But you can see here the lower yard and the upper yard non-operational hours tend to be lower, where operational hours tend to be higher. These are max DBA recorded. You see on one Saturday, Sunday, there was a DBA at 76 that was not associated with Kernan. So it's hard to say when these noises are associated with Kernan or other activities around the area on Glendale Drive. Again, we presented to the county not only the LDN, but the 1 hour LEQ, just to show how noise ranged from activities during the day and at night. And in the lower yard, this was when soil was being constantly moved during the day for a construction project. So this was at highest intensity of the lower yard. Just kind of going through those. I know it's quick. And then talking about standards, the general plan standard is the general plan standard is either a CNEL or an LDN value, which are both 24-hour averages. There's not a specific instantaneous reading that is in the general plan or in the county zoning ordinance. Residential, I can't point. The residential standard is 60, which is what is in the use permit for Kernan. Industrials sources is 70 to 80. And we've demonstrated that Kernan meets that 70 LDN. It was this is copied from the operations plan that was submitted with the use permit application materials, and it was fully disclosed the level of noise that this operation was going to emit. And then I'm going to skip really quick since you're all interested in flooding. And then I will give it back to Praj. So the original firm, which is a flood insurance rate map or the 100-year flood zone map for this area, was done in 1982. It was a very rough, coarse estimate of the floodplain. I find that old firm maps tend to be inaccurate. In 2016, the map was remodeled, and you can see that in the, sorry, can I go backwards? In the, oops, does it not let you go backwards? Lower button. There we go. Oopsie. I'm going forwards. Okay, I'm really challenged right now.
You're fine.
I'll skim, I'll go fast through this and then not go backwards. Sorry about that. All right, so that's the old floodplain. You can see when it was remodeled with detailed hydraulic analysis that the floodplain completely changed. But the area where the lower yard is was not remapped. Typically, when you have smaller watersheds, there not a lot of money goes into detailed modeling for those smaller watersheds. That elevation at the corner of the lower yard is 69 feet. That's important. A flood elevation certificate was submitted with the approved grading plan for this yard. They had an approved grading plan, just want to stress that, demonstrating that the elevation of the flood zone was less or at 69, which is that lower corner of the south yard. I mean, there's an indication, this is all provided to county staff, just demonstrating that that lower yard multiple ways is not in a FEMA floodplain. Remapping could be done. We just haven't had time before this hearing to even consider that. It looks like water backs up on Highway 299. Does it back up at the bridge? Went and got the bridge information from Caltrans, determined the 100-year flow combined from Noisy Creek and Hall Creek, modeled that. There's about 14 feet of freeboard during the 100-year event under that bridge. So during that event, it does not back up behind 299. At least up in the Kernan yard. Damn it, they did it again. Went too far. Anyway, so the next question, what happens near Noisy Creek? Modeled a cross-section at Glendale Drive and 2 cross-sections in Noisy Creek. The combined 100-year flow, what do those cross-section looks like? Here's the cross-section on Glendale Drive. There's the berm. It doesn't even hit the berm, doesn't get on the project site. Here are the 2 cross-sections in Noisy Creek at the berm, so the 100-year doesn't even get to the site. When you look at the event, those aerial images that we looked at, the stormwater pond did not overflow. It did not discharge surface water. That has been validated by the water board. The violation has been removed. There has been no indication that sediment from this yard went directly and there was a discharge to the creek. As you can see here, I wish I can point it, you have water coming over from Glendale Drive, flooding over from the creek. That area that we see there is flooded. It's about a half an acre. It's about a half a foot of depth. If you spread that water that's now the berm's gonna hold in, the berm is put around that edge, it's gonna increase the floodplain upstream of that in that huge flooded area behind Glendale Drive about 0.0 or 0.04 of a foot. And then when you look at the event that actually happened, the highest intensity was over a 3-hour period. It was about 4 inches. And that's about a 500-year event, not a 50-year event. And then I need to go backwards again to get back to Praj's stuff, so if you can.
Just tell me when to stop, please.
Okay.
You're gonna make me dizzy there. Okay,
Praj, pull the microphone closer, please.
okay. Thank you very much. Thank you for that, Angie. I wanted to touch in on the site grading history. Following the 2001 CUP, for 22 years, the site operated without any complaints. The CUP application materials fully described and disclosed publicly all of the proposed operations that are in place today. I did want to touch in just on the noise that while we were here speaking, my noise gauge registered up to 89 decibels here in the room. And so imagine now that would be restricting to a bulldozer or a Caterpillar operating on the project site. The site in the 1950s was developed for timber. This photo here from 1988 shows that there's a log deck on the north yard or lower yard. And I imagine that over the years, the site had been graded many times to support that log deck. Next slide. In the conditional use permit, we see this is the approved site plan. And in that use permit, there was substantial mitigation requirements to work on restoration along Hall Creek and to do protections to Noisy Creek. All the mitigations led to a grading permit, U.S. Army Corps of Engineers permit, and Department of Fish and Game wetland fill permit that did the restoration and corrective action work. Next slide, please. As part of, Angie mentioned that the county in 2004 approved a grading plan for the entire north site, stating that you can see here that it's got stormwater BMPs wrapped around the edge of the site. There is a red line shown there that I want to show. That is the edge of vegetation that existed at the time of project approval, and that edge of vegetation really didn't move over the next 20-some years. I wanted to state a project description from the grading permit indicates that there would be filling of low-quality wetlands, there would be enhancement of about an acre of wetland, and then soil and organic materials, scrap metal will be temporary stockpiled within the designated areas on the site, and a maximum soil stockpile of 345,000 cubic yards. That's like 34,000 dump trucks of material could be stored on the site anywhere that is not a stormwater treatment facility on that map. And it also, the other item authorized under the grading permit was construction of compacted berms and sediment stormwater features around the site. I want to just make the point that what was constructed was stormwater management features. There was a pond constructed, there was a ditch constructed, and there were berms constructed to manage stormwater. That was driven by, as the original project approval had Regional Water Board for Construction standards. Over time, it ended up becoming the Industrial General Permit, and Kernan has worked very hard through the years to maintain compliance with the Industrial General Permit and move forward. And so the question that just want to point out that those stormwater features that are regulatory required have been put in place on this site to protect resources, and at the same time, they had the right to store 345,000 cubic yards anywhere on the site. And next slide. Next slide, please. These slides just demonstrate that the berm that we're talking about was placed, and the red line closest to Noisy Creek is a fence line that Scott Farley put in 2001. And the berm and all the activity that we're talking about has occurred outside of that fence line, and that fence line was the approved protection to Noisy Creek at the time in 2001, and that Kernan Construction has not extended beyond that. In fact, there's now a large berm between the fence and the yard, creating an increased buffer for any construction activity on site. And so he could have placed a large stockpile right there. Instead, he placed a berm to protect the stream and to make sure that there was a further setback from construction activities on site. And then next slide. Then wanted to identify here is an example I put together for the grading permit, just showing all the area behind, in front of those contours in the white paper. That was the entire yard that was able to be used for construction activities. Next slide. Here I've depicted the stormwater pond, the stockpile, the stormwater ditches, and the berm, and all of which are constructed outside of the original buffers and limitations created by the use permit. Next slide. I wanted to just touch it back on the conditions of approval. There was a comment about surveying, and I did depict on the site grading plan from Humboldt County Web GIS, the parcel mapping, but we looked up the record of survey for the neighboring parcel 14 and see that the actual property line is a center line of Noisy Creek. Therefore, there should be zero question that Kernan did any work on the neighboring property.
Thank you.
Thank you.
Brad, before you go, I just wanted to point out something about the two more things about the floodplain. Can I? Yeah, just forward until you see the first aerial image. Nope, keep going, floodplain stuff. That's okay. You're going backwards. One more, I think. One more, right there. So there was discussion regarding that event, and this is the same aerial imagery we were looking at before with the staff's presentation. And the flooding that is going on here is you see Hall Creek flooding over the bridge and going out into the Christie pasture on the other side of the pond. And one more, Brad. And then just demonstrating, you can see that overtopping the creek, going down the road into the pasture. The stormwater pond is in place. The flooding that we saw during this event was one from Glendale Drive getting onto the site. So the berm was to prevent what we call that off-site run-on and to mix with the Kernan site. That's what hit the creek, was the off-site run-on. It would not have happened otherwise, and the berm was put in place as stormwater protection. And so I just wanted to clarify that that was the case.
Thank you. So I'm going to now have staff is going to respond to some of what's been said. But first of all, applicants, meet Joel, the attorney for this project. And so I will have Director Ford respond to some of this.
I think we would prefer to respond after public comment.
Okay, so then does the board have any questions for the applicant? But please limit to not statements, just clarifying questions. And if not, then we're going to open to Brad has something to say. You need to use the other microphone, please.
I apologize. Will we have a brief period of response as well?
If you're asked questions from the board, you can respond.
Okay, thank you.
And I'm sure you will have questions. So we're gonna go out to, first of all, does the board need a break before we start public comment? Okay, so we'll take a 5-minute break and come back, and we're gonna start public comment on Zoom first and then in the room. We'll start with public comment on the Zoom. Can you change the clock to 3 minutes?
Yes. Thank you for your patience. Caller 7718, I will unmute you and you will have 3 minutes.
This is my neighborhood. We're there. I have lived very close to there. And the problem here is not Kernan. I don't know what to say, but a major part of the problem is the county's lack of maintaining the culverts in a manner that precludes some of these things from being necessary. I won't speak with Julie Christie. I do speak with her on a weekly basis, if not more frequently, and I've never had her mention any kind of complaints regarding Kernan or what they do there. I border the Kernan upper yard, I think in totality, if I recall, on the 299 side of the property, and I also border it on the another side there. So I've got an L around them. Multiple rentals there. My tenants have never complained about what's going on there. We get along just fine. We are not somebody who has decided to go after this particular facility. We support them. It should be noted that the residential houses that are about the same distance from the rock crushing as me all had to go ahead and sign an acknowledgement that, yes, they're where they're at and this is the noise they make. So I don't think you're having any of those people coming in and complaining. And you're having people from out of the area, people who do live in the general vicinity. And I understand they'd like to have a perfect world. They'd like to be able to continue to trespass through Kernan's property to get to the river that's been precluded. A security reason that shouldn't have ever happened, but seems to be something they enjoy doing allegedly. Regarding the whatever 30 letters that Rex got regarding the fish hatchery project up there, some people up there ought to be careful what they ask for. For a long time, I've tried to keep the fish hatchery going. If they're going to complain about the people doing their business in the area, maybe it's time for them to do some business also. So I strongly suggest you listen to their legal counsel. I think they're going to put the placards on their things. I can't see them changing their hours of operation. I think they've been adhering to the noise standards. I can't see you changing those to anything different than what's required of anybody else, just because you have some people complaining. And I'm not, nor my tenants, nor do I know the other good people in the area who support construction and the necessary work that Kernan does for all of us out there. Thank you for the opportunity to speak today.
Thank you. That is all on Zoom.
Okay, so we'll go to public comment in the room. I'd like for, if you're going to make public comment, please do line up over by the door and then just come forward when it's your turn. And do we have someone that's going to start? Come forward, I'll close public comment.
Good morning.
Good morning.
I'd just like to say I've been with Kernan for almost 20 years, and we've really done nothing different now as far as noise as we did 20 years ago. I think the problem is most of the neighbors are just now not working or retired, so they can hear it, so it bothers them a little bit. Thank you.
Thank you for your comment. Hi, welcome. Come forward. Speak into the microphone, please.
Yes, thank you very much for allowing me to speak today. My name is Cindy Trobus Thomas. I reside across from the Kernan Construction. I'm writing to express my support and concerns regarding the revised condition of approval for Kernan Construction. The Trobus family, contrary to what people think, that we're all new there, has lived in Glendale for over nearly 70 years. For the most part in harmony with adjacent industrial uses until the last 2 years. Kernan Construction has expanded their operations without regard for residents, environment, and laws. From 2000 through 2004, they have earned over 14 county, state, and federal violations and reprimands. My concern is Kernan continues to ignore the CUP they originally agreed to, and there are no repercussions for their bad behavior. What makes the county believe that all of a sudden they will change and become respectable, responsible operators? I witnessed an exchange between the planning director, John Ford, and Kernan Construction's Scott Farley discussing the construction of the burn adjacent to Noisy Creek. John made it very clear nothing was to be done without a permit. The berm was constructed a few days later without a county permit. It appears the rules do not apply to Kernan Construction. What message does that send to the other businesses in Humboldt County? Maybe there should be a monetary fine assessed for each violation, might encourage Kernan to comply. No violation, no fine. The fines could be used for the restoration and enhancement of both Hall and Noisy Creeks, which are two coho-bearing streams that have been impacted by Kernan's operation. Another thing is in 2006, a CUP was proposed for Kernan hours of operation, and it was going to be 7 to 5, Monday through Friday, occasional Saturdays, no operation on Sundays or national holidays. Occasional means not often, incidental. Although the project was dropped by the Kernan, the hours of operation identified would be appreciated. Operating on Christmas Day was extremely disruptive to our family and memories. In the original 2001 CUP, rock crushing and sorting activities would occur on an average of 50 days a year within the hours of operation. Plus, during winter months, operations were supposed to be reduced. A definition of reduced hours would provide clarity. Please include in the revised CUP. Finally, I support the other items listed in the revised CUP. County staff has worked diligently to work with both Kernan and the neighbors. All that remains is for Kernan to follow the rules. We're not interested in putting them out of business.
Thank you, ma'am. I'm sorry. Your time is up.
I have 1 minute.
No, I'm sorry, you can't.
Oh, it's too bad because it was really nice towards Kernan.
I'm sorry. Please come forward. Hi, welcome.
Hello, I'm David Naylor. I've worked at Kernan since 2001. I'm disappointed to be back here. After the first meeting, I thought this would go away, as it seems to me a hypocritical double standard towards Kernan construction. First thing that seems off to me is the shady part of this, where someone or some group who's trying to build a trail near or through Kernan's work yard helped gather a few neighbors and join the county team led by John Ford. Next is some of the hypocrisy and allegations. After the last meeting, it sounds like our hours and operations are all within the permits the county granted in 2001. I don't blame the neighbors. I sure wouldn't want to live in an industrial zoned area, which is what Glendale is. So when I bought a house, I bought one that was not next to most things I do not like or do not want to hear. The next thing, the nearest thing to a violation, sounds like the lack of a permit for a berm. Even that seems arguable, as the 2001 permit for the area allows for active dirt stockpiling and grading, if I'm not mistaken. But more importantly, never mind that the berm was built to protect the property from obviously neglected neighboring water discharge and county drainage and culvert issues. To top it off, the water in the pictures, which soaks in a creosote bridge, is coming from the upstream neighboring property, whom have teamed up with the county to point the finger downstream at Kernan. There's absolutely no critical thinking. I think that some of the pictures that John's team included in the attachments for this clearly show the county's road, the railroad agency, and the ranch property upstream of Kernan as the cause of flooding. Kernan property and shutting down the Glendale Drive during the winter. What part of your pictures are permitted? How much is the permit to have a 50 or 100-year-old toxic railroad bridge soaking in a large body of water, which then floods Kernan's yard before going into the Mad River? How much is that permit? I do think Kernan can catch up to permits if additional permits are required to protect the property from drainage and creek neglect in the area. I'm sure Kernan can move berms further into their property if it's decided it is too close to the riparian area. But I think it is disingenuous to pretend the berm is the cause of the problems in the pictures. The Glendale Kernan yard doesn't have water runoff outside of extreme rain events when the neighboring land and county road flood onto the property. There are not many industrial sites in the county that can say that. Want help looking for actual water runoff? Right here, there's a big gravel parking lot with big potholes, and when it rains, all the water and fine sediment runs out into the street and into the bay. If Kernan parked trucks here in light, it would be a very clear violation. With the revised conditions I've seen, I worry about how we can stay competitive if we are subject to follow special restraints and others are not. The rules and laws should be the same for everyone and all businesses and government. Kernan should be allowed to have the same noise, hours, and allowance as everyone else.
Hi, welcome.
Hi. Thank you guys for allowing me the opportunity to speak today. My name is Clinton Betts. I've lived on Glendale and in Blue Lake for close to 10 years. I've also worked for Royal Gold for over 6 years now. As a representative of Royal Gold, another industrial operation on Glendale Drive, several of the conditions being placed on a neighboring industrial facility are concerning to us. The precedent that they could set for multiple other operations in our county. These conditions, while in response to some legitimate concerns, would serve to push out industrial operators from our historically industrial neighborhood. I'm especially concerned about the proposal of a 70 decibel limit to be created and the allowance of a cell phone decibel meter to be used to enforce this limit. I think we can all foresee the issues that will arise with this condition. The county's general plan states that construction operations generate maximum noise levels typically ranging from 70 decibels up to nearly 100 decibels at a distance of 50 feet. Additionally, this area was previously home to the railroad. The NCRA EIR, as cited in the county's general plan, calls for the railroad noise at 96 decibels and 85 decibels for train locomotives and cars, respectively, at a distance of 50 feet. The county also states in its general plan that noise from the Highway 299 is 75 decibels CNEL at a distance of 50 feet from the road. I cite these numbers to provide the context of noise in our neighborhood. I suggest that the condition regarding noise in the COA be changed to simply change the backup beepers to an OSHA-approved alternative. My other suggestion for the board is to change the hours of operation to the COA to reflect the realities of a construction company. Restricting all operations to 7 a.m. to 6 p.m. will cripple the ability of Kernan to obtain contracts to do work for Caltrans and the county and these trails that sometimes require operations at night. Please change the COA to restrict only the rock aggregate operations on the facility, not the movement of trucks or the maintenance of necessary equipment. I believe that Director Ford's comment regarding closing the door, as long as that doesn't create additional OSHA violations, is a pertinent and reasonable option. It is becoming harder to run and operate industrial facilities in this county. Please consider that these conditions, while not the intention, could likely mean an end to the company and could set a harmful precedent for other operations in our county. Thank you.
Thank you. Hi, welcome.
My name's Ken Dunn. I've been in this community for almost 70 years now, and I've been in the timber industry in this kind of a climate for 50 years. And the proposal, if you look at it from my perspective, there's two separate issues here. There's the noise and the operating hours, and then there's the environmental issues. So why are we taking them both on at the same time and trying to put them in a package to restrict Kernan's operating hours? If I'm going to be restricted at North Fork Lumber Company in my operating hours because of a handheld noise meter, it's the most ridiculous thing I've ever heard in my life. And we're wasting everybody's time here. Everybody's time. Kernan's, it's costing them money, it's costing everybody in this room money. And let's get in my opinion, let's get the real issues straight here. It's not about what Kernan's are doing. It's about a few complaints, and we're trying to bend over backwards to take care of some of these complaints. I'm like David. I don't live in a neighborhood where there's noise everywhere. I picked my home in a quiet neighborhood because I want to be in a quiet neighborhood. And these people, when they buy their property, they sign a notice that says this is an industrial site. So why should we be penalizing Kernan for this? Thank you for your time.
Thank you. Hi, welcome.
Hi, my name is Johnny Acosta. I've been living in Blue Lake for 41 years, and the whole time I've lived there, that place has been an industrial area, and it's just going away just like how Alter Power did. And so all over noise, which is, you know, there's alternatives for their noise beepers and stuff. I don't understand why they keep on having to go back to it when it's a standard for these guys to have these beepers, but everybody's against them. So I'm just in support for the Kernan to keep working the way they have been. I'd like to thank Scott Farley, and that's all I got to say.
Thank you. Hi, welcome.
Thank you. Good morning. My name is Linda Miller, and I've lived in Glendale since 1996. And I live with my husband, who's lived there since 1973. He did not sign any agreement about industrial, when he bought his house, but there was noise there at that time. We accepted it. We lived with it. I'm very used to the noise. However, let me just read my thing so I don't lose. I do not wish to see Kernan Construction shut down or see anyone lose their job. I also appreciate the products and services that the company provides to the county. However, the company has greatly increased its activities since the 2001 CUP was granted. The increased dust and truck traffic are not adequately addressed in the revised conditions of approval. Please approve revised condition numbers 1, 2, 3, and 4, which all seem quite reasonable, to mitigate the permit violation of grading and placing a new berm within the streamside management area of Noisy Creek. However, the mitigations and the consequences proposed do not adequately address the area between Hall and Noisy Creek, where building of berms and placing fill in the floodplain without engineering plans or grading permits took place last September. Also, considering the history of the bad behavior of this company doing things without permits, please approve the revised conditions for noise and hours of operations. I would like to add that it would be okay with me if the company does equipment maintenance at night, as long as it does not exceed whatever noise limits are agreed to in the conditions of approval or disturb the neighbors. So closing the doors and doing it inside a building would be great. In the operations plan, in the original CUP, it states that each truckload being dumped on the property shall be inspected for any hazardous substances or waste. The county has never received these logs documenting that this has happened, at least as I've been told. There needs to be documentation for these inspections provided to the county to protect the community's health and the health of the Coho streams and wildlife. Also, I believe that requiring the alternative quieter beepers would go a very long way in reducing the noise issues, because the loud beepers are really one of the main issues, and this quieter beepers improve it a tremendous amount. I don't mind the grinding and the dumping of rocks. So the beepers, that would really be appreciated. Thank you.
Thank you. Hi.
Hello,
Welcome.
I'm Gerald Johansson. I live across Glendale Drive from Kernan's upper yard, and I have lived there since 1993, previous to him buying the property and operating there at all. I have no problems with what he does for the county or the state or anyone. I don't want to see him out of business. I have no reason to have that happen. I am very concerned about him not following rules and getting permits when permits are required, and then kind of thumbing his nose up at you and the planning department in the process of doing that. That's my biggest complaint with what he does. The current berm that he put in that goes along Glendale Drive and along Noisy Creek. Noisy Creek feeds out of my property, and there's a creek that comes up down off of Liscombe Hill that feeds into that down at the bottom of the hill. And in 1994, there was flooding there, and my son was taking photography classes at Arcata High at the time, and he went out onto the trestle and took pictures of that lower yard. Again, this is before Kernan Construction bought the property. That whole lower yard was water all the way out to 299 freeway. So with that being said, these berms are backing up water on the upside of the road which my property lies on, and it will have an effect if there's a major flood event again. Anyway, I agree that I agree with what the county is proposing and would like to see those things implemented.
Thank you. Hi. Welcome.
Thank you. My name is Katie
Hold
Rian.
on. Please set the timer. Thank you. Go ahead.
Sorry. My name is Katie Rian. I'm an environmental scientist with the California Department of Fish and Wildlife. I visited this property on several occasions, one of which was on January 30th of this year when I was there with my coworker, John. We took some measurements of the berm and we prepared a field note, which I believe was an attachment on this meeting agenda, and I'm happy to answer any questions about it, about our methods, about our observations, but that was just purely a data collection mission to see what conditions were observed on the ground. So please feel free to ask me questions now or at a later time.
Not now.
Thank you.
Thank you. Hi, welcome.
Hi, my name is John Nichols. I work at Nichols Trucking down the road from Kernan. And I kind of threw out everything that I prepared to talk about because after listening to the opening statement, it seems like all the violations that had supposedly happened are not actually violations. Our working 24 hours a day and loading the dirt out was not a violation. There's only one instance that I heard in 2023 where the rock crushing was outside the hours that were approved originally from this use permit. So I don't understand why we're here. I don't understand why anyone would allow someone to download an app on a cell phone that's uncertified, that's uncalibrated, and to regulate and have authority over a site's noise. I mean, it doesn't add up. And it's not like we're asking, Kern's not asking to run 24/7 all day, all year long. Most of the winter operations are pretty limited and slow. In the summertime when we can work, we gotta work. Sometimes jobs are 24 hours a day. Everyone likes to flush their toilets. Everyone likes to take a shower and have clean drinking water. Everyone likes to drive on nice, smooth roads. But it seems like, there's a few people who want to complain about the noise it takes to do that. I live in a flight path for the airport in McKinleyville. I knew when I moved there that it was going to be noisy. Planes come over all the time. I hear them. It is what it is. That's where I chose to live. I can't do anything about it. 90%, probably 99% of the people who have complaints about the noise coming up from there have moved in since this operation was in place. They have no business complaining about the noise that they chose to move next to. In trying to limit their hours of operation, the ability to maintain equipment after hours it's unreasonable. I don't even understand why it has gotten to this far, why we wasted so much time. I mean, there's maybe a few issues that can be worked out with a berm and culverts and drainage and that kind of stuff. But as far as the hours of operation and the noise that comes from the site, I was out there on Saturday. There was people working in the shop. There was a forklift out there, running around and other equipment. And I was on the Glendale side of the recycle pile, and all I could hear was a lawnmower up the hill and a rooster across the street. I could not hear anything coming from the work being done on the site. So to try to say that they can't maintain equipment is just, I don't understand why we're even here, why we wasted so much money and basically lying about violations that are not violations. I mean, it's like straight up lying. And that's all I have to say.
Thank you. Hi. Welcome. You can pull that microphone down.
Thank
There you
you. Susie Alvarez, down the street from Kernan Construction. A few years ago, a survey was put out about Glendale, and supposedly Glendale residents were invited to take this survey, but it was put out through Blue Lake, on the Blue Lake water bill, which Glendale residents don't get. It was put out through the Blue Lake Chamber of Commerce, which a lot of Glendale people go to McKinleyville Chamber of Commerce. And meetings like this, people in Glendale aren't necessarily notified. We found out about this yesterday. So after that survey was made public, sort of accidentally, I believe, we canvassed our neighborhood. And I talked to about 60% of the residents that live up behind us. And at that point, I realized the math did not work out because I could not find a single person that took that survey, even though the survey said that many of these Glendale residents had taken the survey. And people were angry, and they felt left out of the process that is about them, and they weren't even invited to participate. Many other meetings have occurred that Glendale residents haven't been invited to participate in, so there's a small group of people that seem to be giving all the input, and the mass majority of the people out there are just the silent majority, and they're giving no input at all. So having talked to about 60% of the people, I can tell I have a message for these guys from the 99.9% opinion from those people. And that message is run them. Run them 24/7. Run them 7 days a week. Run them 8 days a week. Run them. You are absolutely right. run them, get these guys to work, let them feed their kids, let them buy a house, let them pay their taxes, let them do what workers do. They survived COVID, they survived an economic downturn, they survived 120% rainfall this year. That makes a small window for people to do work. And that's why these other companies, I was disappointed to hear the paper say that it was just Kernan employees that got up and spoke at that last meeting. What I saw was other companies. All these other companies are here because they know that you got to get your work done in that window. And I'm sorry, but it's loud and noisy and dirty, but when you live in a place like that, and I'm old and I'm retired and sleep is hard to come by at my age, and I say, I'm hearing all the noise, and the noise I hear is actually crime. Gunshots, car bombings, street racing, all that kind of stuff. The Kernan noise, I love it when you guys drive by and honk, make noise and wave. Let that dust fly. Let's get some work done. Well, if you're allergic to work, don't come to Glendale. If you're a go-getter and a hustler and you want to
Thank you.
run them, guys.
No, we're not doing that. You can do your things, but hi, welcome. You can adjust the microphone if you need. Thank
Keith
you.
Dixon. I'm one of two guys in the shop at night. Freaking, I make a majority of the noise, and like this gentleman said, like, can you please shut the door? The door's shut at 7 o'clock. Freaking, all the noise is contained inside. And then like freaking, I've been working like 6, sometimes 7 days a week, because with the whole hours operation stuff and only allowed to do so much. I mean, you can only pull so much stuff into the shop before you got to stop. Freaking, that's why I pretty much had to come in more, is because freaking, in order to keep stuff maintained, you got to get it in. Freaking, like, I'll come in Saturday, get as much as I can handled, load the shop up, shut the doors, come back Saturday night, Sunday. Like, I got a family, I want to hang out with the family, but at the same time, stuff's got to be taken care of. When I do that, freaking, the equipment doesn't come out of the shop till Monday morning, 7 o'clock. Like, freaking, after, what is it? Like, I probably leave like 4 on Saturdays, but I come back. So it's like, I come in the morning, get as much as I can done, load it up, and whatever freaking I can get in is what I got to do. Other than that, freaking shit out of luck, freaking Monday it is, So, yeah, I guess that's all I got. Thank you.
Thank you. Hi. Welcome.
How you doing? My name's Scott Wright. I worked for Kernan for 12 years. I adopted 3 kids from this county, and I think it's bullshit you're trying to shut the thing down. 3 weeks ago, it was raining. It was my day off. They called me and said somebody needed to go up in a man lift to move the lights, so I did, because somebody from Warren Creek was calling, complaining. Warren Creek's a half a mile to 3/4 mile across the road. Thank you.
Thank you. Hi. You can adjust that microphone if you need.
Is this fine?
It is fine.
Okay, great. Good morning. My name is Chelsea Rios, and I'm an owner and project manager at McCullough Construction. In my role, I evaluate project feasibility, constructability, and budgeting before and during project execution. Currently, we have 9 projects where we acquire commodities from Kernan Construction. A typical construction day during peak season begins around 6 a.m. This means crews are prepared and gathering the materials they need, starting construction at 6 a.m. This work can last for about 12 hours, and on some days it may extend even longer. Restricting Kernan to procure and create and have contractors access commodities within an 11-hour window will place a significant burden on everyone, ultimately increasing the time required to successfully complete our projects. This delay will affect the local, state, and federal agencies that have hired us. When we bid on a project, we commit to completing it within a specific number of days. Imposing these hour restrictions will effectively delay our project completion, leading to potential additional costs for contractors, government agencies, and ultimately taxpayers. I am very concerned about the impact of the restriction and who will be paying for that. I urge the Board of Supervisors to consider the financial repercussions that this time restriction may have on various local construction projects, as well as the effects on local, state, and federal agencies and taxpayers. Kernan Construction is a respected local company with over 50 years of operation, and its services are crucial to our ongoing community projects, including the Humboldt Bay Trail. We're almost done. Thank you.
Thank you. Hi, welcome.
My name's Jake Morris. Our family's operated on Glendale Drive for about 30 years. I would echo a lot of what I heard today of why are we here. You know, there needs to be some common ground found. But as Rex stated, there's blood in the water. And if we just took a little common sense and went at this as a company that provides a living for 100 people and their families, let's look at the tax revenue of that. And everything I've heard from their attorney with their conditional use permit, things don't line up. But it seems like some people over here are trying to dirty the water. And as his attorney said, this is going to set a bad precedent for all industrial businesses in this county if this doesn't go the way that it should go. So I'm asking the board to really look at the big picture here. We can't afford to lose any more businesses in this county. It's hard enough to find good jobs that pay with the cost of everything going up. So I just ask the board to please look at it through the right glass. Thank you.
Thanks, Jake. Hi, welcome.
I'm Gary Johnston, Pepe. I'm not up on everything, but I do know that Mr. Ford at that last meeting, what the statement when he was broached on, he said that. I was here. I mean, you know, and the thing is, there's a culvert across that creek at the bottom of the hill there on the Glendale Drive that's been addressed and addressed and addressed. Kernan Construction came in and put a big culvert in below there where his access road is. And that nullified a lot of the backup water that had happened in the past. That culvert is insufficient. They are right about that creosoted bridge. It's been sitting there. That water backs up in there because of that little culvert. But the county has yet to see fit to put a bigger culvert in there. You know, from the noise part of it, you know, I mean, our illustrious government, our agencies demand that we can't work on freeways except at night. So the only way to supply that entity is to supply them at night. It isn't like Kernan works 24/7 out there at night. And I know that there's a lot of discrepancy. There's a few of the older people that the older old timers are complaining about it. But you know, that's an industrial area that's been like that. I'm 78 years old. That mill was in there before I ever graduated out of high school. There was mills there. There was 4 mills there. My little Glendale piece, there was 2 mills there. You know, yeah. I mean, I'm not up enough on it to be able to. I'd like to elaborate real well, but I'm not. But those things, you know. If you guys take a look at like something that Jake said, and I attest to that, yeah, it's controversy. You know, he put that berm in there. That berm is helping as far as I'm concerned. But that water will always back up until that culvert's taken care of. There's going to be water all over that. Thank you.
Thank you. Is there any other? Hi, welcome.
Hi. Thank you.
So please, if you intend to make public comment, could you please line up towards the back of the room? Thank you. Hi.
Hi. My name is Yolanda St. John, and I've worked for Kernan Construction for 14 years. And I've been involved in a lot of what we're talking about today. And I've heard the neighbors say that a lot of the work that was done without a permit. And I just want to reiterate, we had a grading permit for the lower yard. We had a permit for the yard. Now, as Mr. Ford presented, or he explained to me, that wasn't the correct kind of permit, which we learned later, but we did have a permit. And as far as the night working, and we do have the night mechanics, and we have day mechanics, but our shop is not that big, so we can't, for the amount of equipment that we have and the work that needs to be done, we can't have it all done during the day unless we build a bigger shop, which there's that. So anyway, thank you very much.
Thank you. Hi. Welcome.
Hi, I'm Steve Morris. My son and I have property there on Glendale Drive. I'd just like to say that the whole reason that we're here today is of a handful of complainers that have taken upon themselves to make it difficult for Kernan to function, and some bruised egos at the Humboldt County Department because Kernan doesn't run and beg them to get a permit to do something because it takes 6 months to get a permit from them. And that's the whole reason that we're here. And this handful of people that are complaining, they go and they talk to other people and don't tell them the whole story to try to get their support. Just like Miss Trobitz, she stands here and says she's lived there for 78 years, her family has. She lived there until she got out of high school, went away, had a career, retired, and came back there. That's not living there for 78 years. But those are the kind of things that happen, is they don't tell the whole story, or they just tell the part to get some support for somebody in Blue Lake that goes, oh yeah, that'd be good if they did that in Glendale, because I don't live there. But anyway, I think the whole thing's a travesty, and the whole thing really all started from the county not having enough balls to zone the Glendale area heavy industrial. And when I bought my property there, I was after them to do it. Oh no, we ought to leave it unclassified. And that's the whole crux of this whole thing. If it would have been heavy industrial, but all these people that have moved there, they all know what it was. But anyway, I just think it's a shame that we're here having to do this over a few complainers and a few bruised egos. Thanks.
Thank you. Hi. Welcome.
Welcome. Thank you. Jim Smith. I'm a 8-year employee of Kernan Construction. I'm also a retired teacher. I've have a few of these employees that are former students. But what I'm here today to talk about is our safety issue. Both the federal and state requirements for taking care of our equipment are mandated to us. We have to report every 90 days. We have to run our trucks through the shop to make sure that they're safe to run on the highways, to do those jobs that many other people have talked about today. So when you're trying to restrict our hours of operations in our shop, makes it very difficult to do that. Our trucks work during the daytime. In fact, yesterday I was in a truck from about 8:30 in the morning until 4:30 yesterday afternoon. If that truck had something that needed to be repaired so it could work today, maybe we would not be able to do it, make it safe, make it usable. So those are the kinds of things we need to really think about when we talk about restricting the hours of operations for the entire work job. To go back to one other thing that was discussed today, the night that we had that big flood several years ago, for some reason I was the only one that was called in. Blue Lake Rancheria needed a load of sand for their sandbags. Well, I came to the yard, loaded a load of sand in a truck, went over there. And what I realized that evening was the reason that most of the water was coming onto our property was coming on to the property because of those culverts. The water was washing over Glendale Drive and then coming onto the property. And that really disturbed me when I hear people say it is Kernan's problem when actually it's the county who hasn't improved the quality of that road. That road, every time it rains, floods, restricting traffic. The last thing I want to say about this is that this morning when I got to work just shortly before 7, there were 6 trucks sitting, waiting to get on our scales, talking about the trail project. if those trucks don't get loaded early enough, you've got crews of people that are standing waiting for their materials so they can get to work. What does that cost? That costs everybody money, doesn't it? Because it increases the cost of each and every project that we deal with. Thank you.
Thank you. Is there any other public comment in the room? Okay, I'm going to close public comment. Brad, you're going to have a brief time to respond, and then we'll go back to the planning staff.
Thank you, Chair. So I'm going to keep this very brief. I'm just going to close by referring to the recommended conditions of approval. And let's look at these conditions of approval as a way of framing the discussion here. I'm going to work backwards from item number 6 first, related to noise. So staff is recommending that noise generated by the operation shall not exceed 70 decibels dBA at nearby residential properties. Noise levels may be measured and collected using decibel sound meter or sound meter app using Android or iPhone devices. Now, as we've discussed, the only substantial evidence that's been presented to the board shows that Kernan is currently operating within its permit condition. So it is operating in compliance. It's not operating out of compliance. There is no substantial evidence indicating that Kernan is operating in exceedance of the condition of approval or in exceedance of the general plan noise limits, which are actually greater for industrial properties than they are for residential properties, and greater than the limit that's imposed in the use permit for Kernan. Kernan is 60 LDN. The general plan noise limit for industrial properties is 70 LDN. And that's always acceptable, ranging up to 80 LDN for normally acceptable. So I want to make that clear. The condition that staff is recommending, besides the fact that there is no substantial evidence supporting a change to this condition, is, clearly problematic. The general plan, neither general plan nor any other regulation in the county uses dBA standards. It's all CNEL or LDN. And the reason why is that is how you take accurate noise measurements. These spot measurements with dBA are not accurate, and they are not an accurate reflection of the noise being generated by any particular land use. That's the reason why LDN and CNEL are used in the general plan. And the idea that people could walk around with an iPhone or an Android and just take a noise snap and say, oh, this business is operating beyond 70 dBA is inviting trouble, not just for Kernan, all over the county. I don't know why you would adopt that. There's no rationale to it and no substantial evidence supporting it. Condition number 5, hours of operation. We know, as a matter of fact, as Director Ford has already admitted, that Kernan is not operating out of compliance with its existing hours of operation. What's the substantial evidence that supports a change to that condition? There isn't any. And again, substantial evidence isn't people complaining, isn't just we don't like hearing something, it isn't just they were operating late or they were maintaining. That's not substantial evidence supporting an actual nuisance, which it would have to be because we know that those types of activities are not out of compliance with the permit condition. So you have no substantial evidence supporting a change to the hours of operation. Moreover, what staff is recommending actually would work a substantial deprivation of Kernan's business activities by eliminating their ability to serve at night. That is a huge issue. Staff do not address that. You heard staff say it's not going to result in any job loss. Staff aren't in a position to make that statement. This business has to be able to work at night. That's clear. Going to item number 4, coordinate with CDFW staff and the property owner for hand removal of asphalt debris located in the stream channel. Staff presented 0 evidence at all that Kernan is responsible for whatever asphalt debris we're talking about now. Kernan is in the business of recycling and reselling asphalt, not in the business of throwing it away in a creek. There is no evidence that Kernan is responsible for that, and staff has no basis to impose this condition on Kernan. 0. You haven't heard anything. Moving on to conditions 2 and 3. Okay, so let's look at number 2 first. 2A, you heard Mr. White address this survey of the property line. There's no need for a survey. It's already been surveyed. We know where the property line is. It's the center line of the creek. Relocation of all portions of the berm that are within 25 feet of the outside edge of the riparian drip line with noisy creek. So here's the issue. The project that's been approved and the grading plan that was approved in 2004 authorize Kernan to store material, soil, scrap metal, gravel material from tip to tip, edge to edge of that property, including where the berm is. So Kernan could have a 30-foot high pile of debris where that berm is, and that would be in compliance with the permit. Instead, what Kernan did was put a landscaped buffer, which means that it not only prevents runoff or run-on onto the property, but also means that Kernan's activities are actually occurring further away from the actual permit boundary. So why is that a violation? All right. 2C, relocation of all portions of the interior access road leading to the lower yard. That road has been the exact same road for 50 years. It was already approved in the use permit. It's in the site plan that was approved in 2001. So what is the evidentiary basis for requiring some relocation of that road now? You haven't been presented with any. The rest of the pieces relating to utilizing different plantings that CDFW wants, Kernan will do that. That's fine. We didn't get this email from CDFW until Thursday from staff. Staff had it since March 13th. We didn't get it until Thursday. I had to ask for it. I said, please send that to us. There's not been a conversation here. So what we have here in front of us is no substantial evidence supporting any change to noise, no substantial evidence supporting any change to hours of operation whatsoever. No substantial evidence supporting the allegation that Kernan deposited asphalt in the creek. To the extent that there are some allegations regarding the soil condition, I don't know how seriously staff is pursuing that allegation. It didn't appear in the staff report. It does appear in the findings. I'm happy to go through and actually read the language to you on that. There's no violation on that. The idea that Kernan has to submit soil tests, that doesn't appear in the condition. That's false. So the only things we're talking about are a stormwater impoundment and a berm that keeps runoff or run on from coming onto the property. Now, both of those things happened, and I know Praj is an engineer and he's using his engineer mind. He said outside the setback area. What he means is all of that stuff occurred within the operating area approved in 2001. All of that stuff occurred within the operating area where Kernan is approved under the existing permit to install stormwater features, including extensions of the berm. That's condition B11, or B8 rather. So that condition is already in the use permit as well. In fact, maybe I'll just read it into the record. Here's that condition. The applicant operator shall have a screening program to ensure the hazardous, designated, contaminated soil or unauthorized waste are not received. Oh, I'm sorry, that's the wrong one. Here's the condition. The applicant shall file an erosion control plan with monitoring guidelines with the Building Inspection Division. Per Department of Fish and Game recommendations, the applicant shall incorporate retention areas where all surface runoff will be directed and/or extend the series of berms throughout the site to provide for containment of sediment and contaminated materials. That is existing condition A11 in the use permit. So that's what Kernan has done here. They have utilized retention areas and they have directed and extended the series of berms throughout the site to provide for containment of sediment and contaminated materials. So what are we talking about right now? Our contention is there's no basis for this action. We ask that the board find that there is no basis for this action and that Kernan can continue operating in accordance with its approved permit. With that said, Kernan is sensitive to its neighbors and wants and has been working diligently to be a good neighbor. And if changing backup alarms will be a meaningful change, Kernan will happily do that on its vehicles and equipment. Kernan asks for a year to do that because of the expense, and also to keep in mind that there are customer vehicles that come onto the site that Kernan cannot control the backup alarms on those vehicles. So with that, we thank you for your time. We ask that you please make the findings as we have asked. Thank you.
Thank you. Director Ford?
Thank you, Chair. Yeah, there's a couple things I would like to respond to. First, I wanted to clarify that I think I mentioned earlier that there was rock crushing going on in 2023. That's not true. It was rock processing. So first, I want to go back to the original approved site plan. The original approved site plan did show area of operation in the northern yard. It also showed a riparian area along Noisy Creek. The issue here is that that riparian area is representative of the streamside management area. In order to encroach into that streamside management area, even at that time, a special permit would have been required. The special permit that was approved was to allow fill of wetlands and restoration of wetlands within and around the Hall Creek area. It did not authorize storage of material in the SMA along Noisy Creek, nor did it allow filling along Noisy Creek. So I think that's one of the fundamental things that needs to be grasped here, is that that was done without permits. Had they come in for a permit first, we could have had that discussion and developed a plan that would not have led to this. We are not, and let me also say the fence that was put in, it was put in by Mr. Farley as, I guess, a buffer along Noisy Creek. That was not a condition of approval. That was evidently something that Mr. Farley did, and probably with good intentions, but that is not reflective of protecting the SMA. And I also want to make clear the current requirement for a streamside management area is 100 feet measured from the edge of the outer drip line of the riparian zone. When new activity is proposed within an SMA, the new standards are applied. What we're trying to do here is recognize the standards that were in effect at the time. We do agree that if the record of survey shows that the property line is the center line of the creek, then no survey is needed for that. We are not saying that the existing noise that is generated on the site is a violation of the permit. I hope I've made that clear. What we are saying is that there is a degree of discomfort that is causing perhaps even a nuisance for the neighborhood, and we are looking for a way to minimize that. There's a lot of things that have been said about what those conditions should or should not be, and maybe 70 decibels isn't the appropriate measurement for that. The existing measurement of 60 LDN has not been exceeded. Maybe that's an appropriate mechanism to use. And if the applicant or permit holder is willing to accept a condition to change to an alternative form of beepers that has more white noise than that piercing noise, then I think that would be an appropriate modification to condition number 6. In terms of the hours of operation, understand, we put this in here really as a placeholder for a discussion because we had asked the applicant to give us, or the permit holder to give us a proposal for what they would need to operate and how to mitigate the basically off-hour noise. We have none. And it seems that this is coming down to an all or nothing kind of proposal. And I would offer that we agree that, especially if other operators, and there's been testimony to that today, are coming in and they're beginning work at 6 o'clock in the morning, that Kernan shouldn't be restricted from that. I'm grasping for a way to address that other than what's there. Perhaps it could be related to daylight hours that would allow longer hours during the summer construction period, and during the winter time it would slow that down a little bit. I did want to say part of the struggle with the toxic material condition, one of the reasons we believe that that does need to be changed is the way it's currently written. It's reliant upon another department to come in and provide the administering of that, and that department's not doing that. And so I think the presumption at the time the condition was issued was that there would be a department that would be overseeing what's brought onto the site and supervising that. That is not being done. The dust and erosion control conditions that were identified were really related to construction activities and not related to ongoing activities. That's, I got a little sidetracked there, sorry. We do think there is a basis for the action. Number one is that there has been the berm has been placed within the streamside management area. The actual permit that was issued in 2001 did not address allowing any encroachment into the streamside management area. The special permit was issued for other things. There has been a history of doing things without permits on this site, and part of that would just simply, we're not asking for the berm along Glendale Drive to be relocated, but simply the one that's in the streamside management area of Noisy Creek. The issue then is not related to violations of noise or hours of operation, but really raising the question of whether or not it's appropriate to somehow bring some boundaries into place that would protect the neighborhood in some way. I know Supervisor Madrone's questioning of me earlier about that had to do with attempting to reach some kind of a compromise. I think the compromise of putting white noise backup alarms on all the equipment would help. I have trouble addressing the hours of operation beyond that, and I'd be happy to answer any questions.
Okay, thank you. So we're going to start with Supervisor Arroyo.
Thank you. I have some comments to make later, but I want to start with additional clarifying questions. Just to understand the kind of zoning and land use, I know it was part of your presentation and staff report, but I want to clarify that while the land use is in industrial general, the zoning is U combining zone, which means we have very little in the books about what that means and a lot of leeway and discretion as far as how we address any zoning related issues, right?
Correct.
And then across the street, we have residential low density zoned parcels. So it is a very unique circumstance. But I just want to confirm that my understanding of that was correct, right?
You are correct.
Okay. And then with the 2003 grading permit that the applicant's representatives talked about, could you, so I understand from what you said that maybe there was a misunderstanding with that, or that the grading permit did not cover those elements, but could you speak to what they brought up with respect to that grading permit?
Yeah. So obviously the grading permit allowed the site to be graded to fill the wetlands to create an operating area out there. The thing the grading permit did, and it allowed for the berm along the south side of Hall Creek. It also allowed a rather large drainage ditch along the north side of the road that goes along the south side of the northern Yark. When you start getting into an area where you're putting in a structure to retain water, that's a different issue. That's not stockpiling material anymore. That's now an engineered structure, because now, especially when it's built with a berm, is above ground, has the ability to fail, that is an important consideration to make sure that that's engineered, compacted properly, built properly. The same is true with the berm. And while we could get very lost in discussion about floodplain or not floodplain. The fact of the matter is that is intended to redirect floodwater. And so, again, it's important when you're putting a structural element in to actually have an engineered analysis done, to have permits issued. And so that's why those aren't covered under the original grading permit that was issued in 2003.
And did the original grading permit from 2003 authorize construction within the streamside management area?
Not that we can find.
Okay. And then was there, I just have a couple more quick questions. Was there any...
Could I
I'm sorry.
add a clarification to that? One of the struggles I have is the plans that were submitted are pretty vague to begin with. So I will grant that as an element of transparency. I mean, there could be lack of clarity there, but there was never a special permit issued to encroach into the streamside management area. But the streamside management area was never really called out on the plans, even though it existed.
Okay. And then with the October 2023 notice of violation, I can't tell from the attachments what the response to that was. Is that sort of what all precipitated us being here today, or was there a response to it?
So this has been a really long process. And there was never a notice of violation issued. I tried to correct Mr. Doris about that, because a notice of violation is a technical code enforcement action, and we've not actually taken a code enforcement action on this site. We did indicate that the site was in violation, and violation, I guess, is, that gets kind of nuanced, but we did inform them that the construction of the fence, construction of the impoundment without permits, were violations of the zoning ordinance and also of the building ordinance, or building code. And there was not a rapid response.
Okay. And sorry, just one more, and then I'll be done with my questions for now. So when I look at the noise compatibility section of the noise element of the general plan, it is a square peg round hole situation with this property, because there's some noise compatibility standards that apply to specific land uses, but those are sourced from another document, and then our short-term noise standards are one thing, but there isn't, as we've discussed before, our noise element is I'll just say a little bit broad. So it talks about acceptable daytime levels in industrial and commercial areas based on a combination of health and nuisance considerations, don't exceed 85 dBA, but in residential standards, in the 60s dBA. It looks like your recommendation kind of went for something in the middle of those. Was that?
Yep.
To understand just where that came from? Okay. All right. Yeah, this is a very unique situation, so I look forward to hearing what my colleagues think.
Supervisor Madrone, or excuse me, Wilson.
I got a couple questions to throw in there. Sure, why not? Along the lines of the questioning around the grading permit, and it seems like the applicant's interpretation that if you can store, and I don't even know if that necessarily within some sort of boundary, that then building a berm is okay. I mean, it seems that's what I'm hearing, and there seems to be a bit of a disagreement around that, because a berm isn't just a storage of material; it's an engineered structure with purpose. And so, is that what I'm kind of hearing?
That's what you're hearing, and that's what you heard Yolene kind of acknowledge. We did have that discussion.
Okay.
So I'm fine with it being an honest misunderstanding.
Okay. I mean, because and what I'm going off of is the findings from the resolution. I mean, that's the evidentiary part of that we're supposed, that we're asked to, if we're concluding with staff going through that. I guess what I'm not seeing in there is any, I haven't seen any arguments from the applicant that really go at the findings that we're supposed to be looking at today. And we could change those findings, I suppose, and if we modify the outcome here, we would have to do that. But I don't see anything in there that, in terms of the evidence, because there is evidence enumerated in there, and it's not any of the evidence necessarily that the applicant is talking about. There seems to be two different worlds of evidence that are being discussed here. And so that was confusing to me in terms of what we were receiving. So from that perspective, I'm a little bit confused. Can you do you see that difference between the evidence that we're reviewing in the resolution versus the evidence that's being presented by the applicant?
I do, and some of it really has to do with trying to address larger issues without addressing the specific issue at hand.
Okay.
I mean, from staff's perspective, there is one thing that needs to be addressed, which is whether or not that berm was constructed in the SMA inappropriately.
Right. Okay.
And we believe that it was.
Okay, and so evidentially, we only have to find one violation, really, to basically, in that list, to be true, to have the ability to talk about basically reopening this permit process, right? That's what we're doing right now. So it doesn't, you could quibble and fight about all these different things, but if there's just one of them that's off, that there is evidence that this is wrong, that the permit has been violated, that's it. We're at here we are at the table. Is that correct?
But I would say that's correct. In this particular case, it's probably more accurately stated that it's a violation of the zoning ordinance, which a permit is required to be in compliance with.
Okay, thank you. Appreciate that. So I just wanted to kind of get my head around that. I'm going to take a little side trip here for a second, which is around the lighting violations that were occurring, or maybe even complaints. And I was just wondering, it seems like when we were here last that there was the thought that had been addressed, that shielding had been applied, and but then I heard someone come in and say that they had to address some of those lighting issues.
We've gotten a series of lighting complaints.
Okay.
And to Kernan's credit, they have addressed those each time that we've contacted them about it.
Yeah.
They have gone out and addressed that.
Well, I appreciate that, because in all honesty, it's like one of the easiest things and cheapest things for people to deal with is light pollution, because it's basically like redirecting a sprinkler, honestly. It's like just shade it and have the whatever the frequency of it in the right space, and it works pretty well, and we get to protect our night skies that we value as people who live in rural areas. So I really appreciate that. It's a really very valuable response. I did take a look at the report from CFW, and it is eye-opening from the perspective of it. There is direct evidence that this is and they show photos, this is a coho bearing stream. There was evidence of spawning and of spawned out carcasses in this space. So this isn't not an it's not it's a significant resource is what I'm getting at. It's not insignificant that we're having this discussion about this stream. It's not just any old stream. It has it's fish bearing, and it's important, and that's important to all of us too, for all those of us who fish and those of us who are in the community. That's part of our why we're here. So I think that Kernan would want to and would want to be responsible to the protection of that, and I haven't heard them say that they're not wanting to do that. In terms of the asphalt that's in the creek, and what I heard the representatives for Kern say that's no evidence that that's ours. Is there, I just kind of wondering, like, is there somewhere else that one would imagine it would come from in that location, or is most of the watershed above those locations Kernan Yard? Or
Well, above upstream from that point is Glendale Drive, and then the culverts, and then other property upstream. Staff would not have any idea of where it would come from if it didn't come from this side.
Okay, but it is on Kernan property if they say their property goes into the creek, right?
Based upon the testimony we heard today, that is correct.
Okay, so at the very least, the violation of these whatever these materials is on Kernan property according to testimony we heard today. Right. So it would seem to me that as property owner, you'd want to have, that would be something that would be of concern and importance in this discussion. There was questions around, and I heard the applicant, and is this what we're calling Kernan Construction today, is the applicant? Is that
I think they're better understood as the permit holder.
The permit holder. Thanks for the clarification. That some of these berms that were discussed didn't even get touched by floodwaters at all. And the question was, well, why are we concerned if they didn't get touched by floodwaters at all? And then that kind of gets me to the point of, well, then why have the berms at all if they're not being useful? So then what is the point in terms of the engineered structures? And maybe it's noise mitigation, maybe it's just projected flood mitigation, but I'm wondering, but those particular berms are not the berms that we're most concerned about. Is that right?
No, those berms we are concerned about.
Okay.
And as part of the grading plan, we'll be looking at what the potential impact to the water surface elevation is.
Okay.
You saw in the pictures that the permit holder presented,
right,
that a portion, that corner of that yard was inundated.
Right.
And so the berm is intended to preclude that from happening.
Okay. But what they stated is that it didn't get used because it never got touched by the flood water.
I understand that.
Okay. Okay. And then sort of just the last, and again, I apologize for just kind of bopping around. My notes are, if anyone's ever seen my notes before, they're not the most organized thing. Not a lot of nods up here. So on the noise perspective here, it's hard for me to imagine that there isn't some kind of noise mitigation that's not possible associated with a mechanic shop and the structure within. I think that we devise all kinds of buildings and engineering engineer designs around how we mitigate for that. I myself, as a musician who has disturbed many people in my life at very odd hours and had, you've all been there. I've also been that bad neighbor when I was younger. So what I'm getting at is so then what we would do is try and mitigate that with whatever we could, mattresses and eggshell cartons or whatever, all that stuff. Never worked very well, but people have done much better jobs of that with some resources in these sort of areas. And I'm just sort of wondering, what I'm hearing is that there was just never really a response from the permit holder to try and mitigate in any sort of way or have sort of any kind of engineered, they're engineering these berms. Has there been any response around engineering any kind of mitigation to sort of hold it down a little bit so that, because I would love it to have every shop in Humboldt County that wants to work all night long not disturb their neighbors. That would be awesome. It's just, sometimes they're just in these old spaces or whatever, and there's upgrades that can be done to help that out. So I was just wondering, did we hear from them on anything
We,
that was
we,
offered?
we asked for that, we did not receive that.
Okay.
And let me just say, I didn't really want to challenge this too much because I appreciated the mechanic that got up and spoke.
Yeah.
But
I really, I freaking did too. Gonna say.
Is that unfortunately we do have pictures at night of the doors being open of the shop, and we do have a sheriff's report that was based upon a complaint. The sheriff's deputy went out, responded to the site, walked into the shop that was open. He just walked in, and that's in his report.
Okay.
And so to say that the doors are always closed, I know there's at least a couple instances where that's not true.
Okay, that's the end of my questions for now. I appreciate you letting me go down those roads. Thanks.
Supervisor Madrone?
Thank you, Chair. So the reason we're here, really, to be blunt, is that in the fall of 2023, things changed dramatically with all-night operations, and it wasn't just for a couple of weeks, it was for several months. And that just really triggered a lot of nuisance, concerns on the part of the neighborhood. That's why we're here. It's not the county trying to put Kernan through anything. It was Scott Farley and Kernan deciding to operate all night long. And yeah, I get it. I mean, the Indianola project, Caltrans projects requires night operations. That's the only time they'll give you encroachment permits. And I realize that that is a real conundrum. I absolutely do. But it was that decision to go ahead and operate all night long, night after night, 7 days a week, that triggered the response from the neighborhood. I think it's really unfair to say that neighbors have said they want to put Kernan out of business. I see no evidence of that. I've never seen that in writing or in statement. In fact, I have always heard, as was stated here today and at the hearing back in December, from neighbors that they absolutely recognize the value of this operation and that they're not trying to put Kernan out of business. What they're trying to do is get them to be responsible neighbors and do what they can to try and reduce those nuisances and impacts on their lives as well. At the December meeting in Blue Lake at the little building there at where the city council meets, Scott agreed to shift everything to the quackers rather than the beepers, and that still has not occurred. A couple of them have been done, but it has not been done for the bulk of the equipment on the site, as evidenced by the fact that there are beepers that still go off on a regular basis there. And I know that it's not just Kernan. It's been shown that, in fact, Eureka Sand and Gravel over on the highway has beepers going off when they're backing up, as well as Royal Gold, as well as Morris, as well as Pepe and others. Now, none of them are here today in this hearing being talked about per se, but I just would say that I've heard from some of the residences that simply shifting to the quackers, the white noise as it's called, rather than the beepers, would go a long way towards mitigating sound impacts to the neighborhood. And while those other businesses are not part of this hearing, I would just suggest that a good neighbor approach might be for them to consider also adopting that practice of shifting over to the quackers. It doesn't change the business operation. Does it cost some money? Yeah, I get that. It's also been mentioned that the old North Coast Railroad trestle is a huge potential hazard to Coho, and I agree with that. So as I sit on that board, we have budgeted for removal of that trestle and mitigation of any soil contamination that's occurred with that. That project will be occurring over this next year or so. In addition, the county culverts have been brought up a lot. Yeah, they are undersized, and they have contributed to flooding over Glendale Drive. So over the last 2 months, I've been able to pull together a team of people that are submitting a proposal this week to get funding from the Department of Fish and Wildlife, hopefully, to actually replace the culverts on Noisy Creek and Hall Mill Creek with properly sized culverts to handle 100-year flow events. And so that is in process as well. So, it's not just Kernan here that has some responsibility. We all ultimately have responsibility typically in things like this. And so I just wanted to speak to that responsibility on the part of the Great Redwood Trail, as well as the county. So we're taking actions to fix those things. And that's all we're simply asking of Kernan too, is to try and do the best to fix those issues that continue to be a problem in the neighborhood. And it is complicated having industrial uses and residential uses so closely aligned with each other. That's not an easy thing to try and solve. So, you know, I'm trying to find a way forward where we can continue to have this business operate, but also make it a little less impactful on the neighborhood. Back in the 1980s, when Blue Chip Mill came in to take over that site, and they were chipping, there were complaints that happened. There was a presentation here today with some slides that said there were never any complaints during this period. There were complaints filed, and the outcome of that was that the Blue Chip Mill had to build a bunch of buildings to enclose their chipping operations and the noisy parts of their operation inside buildings. And they also had to make sure that the trucking went straight to the freeway rather than through Glendale. And there were a number of other conditions that were placed on that operation. That was before Kernan. But there were complaints and there were changes in conditions that were placed on the business in order to try and deal with those impacts. Many of the complaining parties have lived there for 30 to 70 years, maybe not continuously, but many of them have. And they have always dealt with industry. Many of them were members of industry. And they're really just trying to say, can we just do better and do our best to be neighbors and do the things that are within reason to try and allow for this operation to continue while also reducing the impacts. So that's really where I'm going with this, and I'm going to go ahead and make a motion. I'm going to make a motion to approve the staff recommendations with the following modifications.
What?
The modifications that I would suggest in the motion would be in regards to noise. I think that we could probably stay with the LDN as it is, and I know that's been argued here to maintain that. The 70 decibels is problematic. I recognize that. So it was mentioned in the staff report, go to the 70 decibels or to change over to the white noise quacker type of sound system rather than the beepers. So that would be the condition that I would change, or at least validate that or in the staff report, that under noise, all equipment to use the quackers to be installed within 3 months, and you could continue with the LDN as it is. Under hours of operation, I would add a condition that would allow for equipment maintenance to happen after hours, as long as it is in a closed building and the door is actually closed. And this, we had several testimonies here around all of that. On dust control, there has been a lot of issues with dust. I know one person said, let the dust fly. Well, you know, there are a lot of issues with the dust, and I've had a lot of complaints about that in that neighborhood. So the condition there would be to add a condition that the operator, the permit holder, submit a dust control plan within 2 months for consideration of approval by planning and building. Dust control is a pretty straightforward thing, where you cover the piles if they're not active with tarps and or tire weight down systems, or you water it down on a regular basis to prevent that dust. It gets very windy out there and dust has been an issue. The last condition would be, or modification to the staff recommendation, would be on soils testing, and that would be to submit an annual report with the testing records to planning and building. Theoretically, they're already being tested, the soils, and that was talked about here in testimony as well, but there has never been a report submitted. There were a couple of tests recently done, and that information was submitted, but there ought to be an annual testing, because in construction, there can be contaminated soils. And that's why this condition was placed on the permit in the beginning, was because of that concern about contaminated soils. So that would be the last condition. Just to summarize that, the motion is to approve the staff recommendations with the following modifications. Noise, to shift within 3 months to the quackers, the white noise, rather than the beepers. The LDN to stay the same. Hours of operation would allow equipment maintenance after the hours in the staff report, as recommended, as long as it's in a closed building. Dust control, submit the dust control plan within 2 months for consideration of approval by planning and building. And lastly, soils testing, to submit annual report with testing records to planning and building. So that would be my motion.
Well, thanks for the motion. I guess we can see if we get a second, but I do believe 2 other supervisors have questions, so I'm not seeing a second.
Yeah, I'm not prepared to
Okay.
second until I hear some of the rest of the stuff, but I'm not totally adverse to the motion
Okay.
as it's been put forth.
I wanted to,
That's fine.
if I could ask Mr. Farley to come forward. I wanted to ask you about, you can come to the microphone, please. I wanted to ask you about mitigations that have happened with taking the beepers off. Have you done any of that replacement work on the equipment to remove those beepers and put what they're calling a clacker, I guess, on there?
Yeah, my staff tells me we've installed 15 of those on the equipment that's normally in the yard, and we're working towards getting our whole fleet switched over to that. So I believe the statement of we've only done 2 is pretty inaccurate.
Okay. And then also I wanted to ask you about the doors on the shop. I know sometimes if a vehicle is running, you have to kind of crack the doors a little bit to allow the exhaust to go out. Is there, first of all, do you have ventilation in there? Is it an older shop? What, can you kind of explain that?
It's an older shop for sure. I'm not so sure that when the sheriff didn't show up that the man door wasn't open and he walked in the man door.
And that would be just like a regular in and out door?
Personnel door.
What does the door, is it open doors, roll-up doors?
There's a roll-up door on each end of the shop.
Okay, to drive, so you could drive
Yes.
through. Okay. Okay. Those are the extent of my questions, and I think Supervisor Bohn has some more. My extent of questions to you, I have some other for the planning department. And I think Supervisor Bohn wanted to talk. Sure, I can ask. So I was wondering about thank you, Scott. I was wondering about the stockpiling, and so you said that it wasn't allowed or not an allowed use where the berm was placed?
That would be within the streamside management area, that's correct.
So there's 2, and I'm just trying to visualize because I haven't been to the site. So there's 2 berms, one in the SMA and then one forward of the SMA?
No, think of it as a big L formed by Glendale Drive and then Noisy Creek.
Okay.
One berm goes, there's several berms, sorry.
Yeah.
The new berms, new berm goes along Glendale Drive and then curves and goes around Noisy Creek.
Okay.
There was an original berm installed as part of the original grading permit to fill wetlands.
Okay.
And to do a wetland restoration plan within Hall Creek that was contained by a berm that goes along the south side of Hall Creek.
Okay.
That was installed with the original grading permit.
Okay.
The berm that is along Glendale Drive and Noisy Creek was not approved as part of that original grading permit.
And that wouldn't be considered stockpiling, and even if it was, that's not permitted there?
So arguably it could be done along Glendale, although that was supposed to be, the site plan shows that that was a vegetated area. So in order to put that berm in, one of the things that happened is that all the vegetation was removed, which completely opened up the yard to Glendale Drive. So I wouldn't interpret that stockpiling was allowed within that riparian corridor.
Okay.
Okay? There is a large ancient stockpile of dirt there. It may have been there before Kernan, that had trees and vegetation and other things on it. And part of that was modified to put that new berm in.
Okay. Go ahead.
Then there's the area along Noisy Creek. That is within the SMA, and that is distinct and separate from and has different issues than the berm along Glendale Drive.
So when you're talking about a permit was not issued for that berm in the SMA area, but we didn't issue violations? Or we did?
That is really the thing that precipitated the revocation action.
Was that we issued violations because they didn't get a permit? Or they didn't get a permit?
They didn't get a permit, And that was in addition to the other violations that have occurred that we were, frankly, even at that point when that berm was installed, had not received a completed grading plan for the impoundment pond that had been installed. That had been, I don't want to exaggerate, but probably at least a year-long discussion to try to get to a point where there was a complete grading permit that was submitted for that.
Okay.
Then there was a fence that was installed that exceeded the 7-foot height limit. When it was originally installed, it exceeded the 6-foot height limit, but as you recall, we modified those provisions to allow 7-foot fences. Mr. Farley cut that down to 7 feet to remove that violation.
So that's not really an issue any longer?
That's not an issue.
Okay. Because there isn't, on the current permit, there is no hours of service, it doesn't look like. And so we don't have to really condition those hours on today's motions, is that correct?
You don't have to do it, no. We are proposing to do it based upon some evidence that's based first on testimony and then is based upon staff being out on site experiencing the early morning hours when things are going on, because noise is very different. And in that area, before 7 o'clock in the morning, there's not much activity. You can actually hear 299. By about 8 o'clock in the morning, 299 is inaudible, and the noise from other activity is now what you hear. And so overall, it is a very quiet area, and so that's why we were looking to try to address how to protect that a little bit.
So when your staff was out there, was it the noise coming from Kernan, or, because I had heard last time that, or from somewhere, that the noise was, they weren't able to determine if the noise was from Kernan or if it was a combination of noise, et cetera.
So there was a point in time where we were responding to complaints. We went out and were monitoring the site. It was before 7 o'clock in the morning, and the noise was actually coming from Eureka Rocks. And we contacted them, and they do have hours of operation limitations, and they have come into compliance with that.
Okay, so it was never determined that the noise was coming from Kernan? No, Eureka Ready Mix is not Kernan.
No, I understand.
Yeah. I said it was never determined that it was coming from.
It was not Kernan. There were early instances where the noise was coming from Kernan, but in fairness to Kernan, they did really work to modify their operational hours.
Okay. And then and I think it's possible, but it's possible to, if we're going to do hours of service, that we can do it, say, longer hours during the work season, which is starting now till October or when it rains again. So it's possible that through if this board chooses to do that, that we could allow longer work hours during the work season. That's correct?
Yep.
Okay. And then fence, building, zoning, replacement. I think those are all my questions for right now. Supervisor Bohn?
I don't know. So what hours of operation are not part of we're talking about conditioning those because we've realized that is not part of the condition in the use permit now, right?
That is correct. It comes under that section that Mr. Doris put up on the screen, which was 14.1.2.3, which identified that a permit may be revoked or modified if it's determined to be a nuisance. And I think Mr. Johnson was very clear about, there are specific findings for what a nuisance is, and what a nuisance really comes down to is when it affects people's ability to just be on their property. It's not just a minor amount of noise. It's not that you hear it. It really has to be something that is so overwhelming that it deprives somebody of being able to be on their property.
Okay. Because a truck driving by on Glendale Road will hit between 82 and 87 just driving down Glendale Road, and there's a lot of trucks not included with this. So I'm just, it's such a fine line. Anyway. Lighting, it's so funny. John, how long we've been working on lighting? You've got a Caltrans engineer working with you on a lighting, situation. The reason there's so much lighting is because there's so much damn crime. They don't light it up just because they want everybody to see what they have. They want everybody to see who's going on their property to take what they have. So I know for a fact because I just put up a new security light. And then on the SMA, is it on the 2003 permit? Is that right?
2001, 2, yeah.
Yeah. Is the SMA called out on that? Because it sounds like they've got an engineered berm that is in violation, and it was added on later and everything else, but they would be able to pile dirt there or rock there now without any engineering?
I mean, when you look at the technical aspects of it, there was never an approved encroachment into the SMA.
Okay.
The site plan does show a repairing area, and it's hard to believe that in 2001 we have what is essentially a hand-drawn site plan, but that's what we have to enforce at this point. But it does show a repairing area along the bank of the stream. There was an SMA ordinance in effect at the time, which was 25 feet from the top of the bank. So there should not, without approval of a special permit, to do anything in that, including stockpiling material or even storing trailers or metal, there shouldn't have been anything going on within 25 feet of the top of the bank.
Okay. But that's just, it's not written, it's just, is that written in the plan, or?
It's not addressed in the plan.
Okay. It just seems, I know we're going back to 2001, you keep saying it's handwritten, and it's amazing how many times you used to be able to go into building planning. I know very well, because I was in the midst of building a ball field and everything else, how you used to be able to change things. And then certain, and no offense against you out there, but Fish and Game became Fish and Wildlife, and they expanded extremely with biologists and say, well, I don't know what she had a pretty big title, what she had. But the aspect of all the hoops we have to go through has probably put us in this situation where we're having all these issues. But what I'm trying, and I know we're zoned U there, and I don't know why, but is there a historical record that's been industrial for 70 years that I know of, probably 65, 70 years?
That's well documented.
Yeah. So I think it's pretty obviously what it is, or what you could interpret it to be without even looking it up to find out it's still a U. And then I think the big elephant is you were working with Kernan trying to come up with answers to all of this that was amicable for everybody to keep people working, summer months, longer hours during the summer months. That is when most of the work, but also realizing that if there's going to be times when emergency work comes forward, i.e. 36. Imagine if you had 10 houses next to Highway 36 out the slide, but they didn't want anybody working on it at night. It's just, how do we address that, and why? It sounds like the communications between Kernan and Planning and Building broke down. Would that be a fair assumption, or?
Yeah, I don't know what happened. We had what I thought was a fairly productive meeting. We talked about how to try to formulate a plan to bring back to the board. And it had two components to it, what to do with the berm and what to do with noise and hours of operation. The representatives of Kernan wanted to go and negotiate with CDFW to determine what an acceptable setback would be from the creek. That was where that was left in that meeting, is they were going to have that conversation and get back to us. And then we'd ask that they address how we can meet their needs for their operational hours and noise, but also try to give some protection to the community to take some of the edge off. And they were supposed to come back to us with that. In response, we got a revised grading plan in response to the previous comments that the building division had made on the grading permit application. And it showed the berm in the same place. So at that point, we took that as the answer.
Understood. Well, I know the work has to get done. I know it has to be, it's somewhat in a cohesive manner with the neighborhood. And I know that a couple of the applicants were real big on some other issues that have taken out there that they've been able to shut down. So I'm like I said earlier, I'm really concerned because now I don't want people to feel empowered that they can go all over the county and shut people down because they can get 20 people together, 30 people together to say, this isn't working for me. Knowing full well that 80%, we'll give them the other 80% bought, because there's probably right across the street, there's 5, 6, 8 houses that have been built within the last 10 or 15 years. Obviously, and they sold, so, and there's some down the street that are new homes that have been built, so they're fully aware. But most of all, I want to make sure that what we do here can transfer to any industrial zone, non-industrial zone, it sounds like, anything else, to stop it. But I agree with the backup. No, I agree, and I appreciate that, and I've been out there. 15 pieces of equipment, which is going to be your loaders and all that equipment, already have these improved backup alarms. It sounds like they're going to do the rest of them as they can. We're asking them to do this coming out of winter. But I'm not really sure. Hours of operation, maybe in the serenity of the wintertime and everything else, I mean, knowing full well that it's harder to work at nights, and the yard work probably doesn't happen as much as the off-site work. But with that, during the summer hours, a lot of these guys are laid off during the winter. So, there isn't full construction going on. Right now, it's to the wall. This is where you make your money. And a lot of these guys live off their overtime. If we restrict these hours, I mean, in all honesty, restricting them 7 to 6, man, you're killing 4 hours of good work time, especially the on-premise work to do the off-site work. So I don't know if I know I can't support that motion that was thrown out there. So I want to know why the compromise failed. You probably don't have an answer, or you answered it as well as you could. There is, bigger things at play here, I believe.
Supervisor Arroyo?
Thanks. I'd like to cut to the chase and see what I heard a lot about why, from your perspective, you don't believe these are these conditions, or that there is a lack of compliance, and that not all these conditions are something you can live with. So I'd love to hear what of these conditions of approval, I'd just like to hear in more specific detail which of these conditions of approval you're willing to work with, and how do you think you can be a better neighbor to the folks who have reached out to us in abundance. Not as many of them are here today, but we certainly heard a lot of public comment that we received that's in the staff or attached to this item. So we're certainly hearing from the community, and like the rest of my board, I don't think any of us want to see Kernan Construction shut down or impacted from employing people and doing good work in our community. So what else can you do here?
Yeah.
Well, do you want to have a few minutes? And I know Supervisor Wilson had a question. He has one question. I'm going to let him throw it in, and then you guys can answer Supervisor Arroyo.
My question to the director was, did Fish and Wildlife offer a setback that they thought was reasonable in that location?
We discussed what a reasonable setback would be with CDFW, and they thought that a proposal of 25 feet, recognizing the original SMA measured from the current beginning point, which is the edge of the riparian drip line, would be an adequate setback.
Okay, so it was done in consultation?
Yes, it was done in
That was my
consultation.
only question. Thanks.
Yeah, let's take a 10-minute break and let council talk. We need a break anyways, so.
Okay, I was gonna say, we're ready to go. if you
No,
are,
we're gonna
but
take a
we'll
10-minute
time.
break, and then we'll come back, so you guys can, and then we answer Supervisor Arroyo's question. I wonder where Mr. Wilson is. I understand that, Praj. Yeah, they're gonna come. Before we go to Mr. Johnson, we're gonna go to Mr. Van Hattem from Fish and Wildlife. And I understand he has something he would like to. There you go. Hi, welcome. You can pull that microphone down.
Sure, thank you. Thank you, supervisors. I'm here simply to answer your questions. So we've been involved in this for some time now, and I actually go back to the 2003 era when I was a consultant. But our purpose with this memo was to try to give you some factual information about what exists today. And my team did the measurements in coordination with Angie and Jolyn. Sorry, Yolen, I have such a hard time with her name. And, you know, Noisy Creek's important. You saw the fish. We saw the fish when we were there during the visit. And we worked with the county in consultation and with these guys as if they ever wanted to talk. We also provided an email that would help with the planting palette to achieve a better noise and visual barrier. So we think that that's an improvement. I think the work that was done was fine, but it was a little more oriented towards diversity versus the physical sound and visual barrier that would be better for that site. And you know, we're big fans of buffers. We think those are the most powerful tool that we have for protecting streams. And in the case of what's there right now, it's pretty small. So the thought was to move it out from the berm that's there, that was reconstructed along Noisy Creek. And again, we're only talking about Noisy Creek here, and get it at 25 feet out, which is seemed like a good compromise and would do the job, especially with the planting palette that Katie provided that will do a better job overall. Likewise, our thought was when the stream dries, presumably it does, that we could go in with a bunch of Kernan folks and hand remove the asphalt that got there somehow in the past. And that would be better for the stream as well, because it essentially, and you can see this in the photographs, it locks up the bed of the channel. And that's apparent in figure 6 of our field note. So not good, but we need to get it out. And assuming the property owners, it sounds like the line is more in the center of the stream. Assuming the other landowner is good with that, we would do that midsummer with everybody's help. Probably get it done in a couple hours.
Okay, thank you. Is there any questions from the board? Okay, well, I really appreciate that. Thanks so much.
And like I said, I had Katie speak because she actually took the measurements.
Okay, thank you.
Okay.
So we're going to go to Brad now and to answer Supervisor Arroyo's question
Yes.
so that we can try to get a motion formed.
Yes, okay, and I'm going to start with a couple of quick clarifications, and then I will directly answer Supervisor Arroyo's question. I have clear direction from Kernan Construction on how to go on this. So, first is, in terms of negotiations on operating hours. Well, Director Ford on December 3rd said the operating hours were not a violation, and he's not putting that forward. So why would we did not understand that we needed to do anything more on that? It's not a violation. That's stated on the record. Regarding hours and noise issue together, so I want to be very, very clear here. There are cases, Goat Hill Cavern, Transoceanic. Once the use permit is granted, you cannot modify those conditions unless there is a disregard of those conditions or an actual nuisance supported by substantial evidence. There has been no substantial evidence put forward in this hearing supporting any change to the hours or noise. My understanding is the hours of operation would be modified because of noise concerns, but the only substantial evidence relates to showing that the noise is in compliance. So I want to make that very clear. Just because there's something that can be done better, now that it's 25 years later, that's not substantial evidence that allows the county to revisit those conditions. So with that, lastly, just to be very clear, no, there has not been a notice of violation issued for any of these issues. So we went straight from, I guess, no notice of violation to a permit revocation proceeding. That's how we got here. Okay, with that, so let's start with the with the berm, because I actually think that's an easier resolution than the hours and the noise. But so let's start there. Kernan Construction, and this is all, of course, with the caveat and with the qualification that we do not believe that there is any evidence of a violation out there. So I'll just make that point clear for all of these. For the berm, Kernan will agree to move that berm, that one location along Noisy Creek, 25 feet. So Kernan agrees to do that. Now, my reading of these, and this would be this recommended condition of approval 2B and D, seem to be repetitive. Maybe they're duplicates, but the point is that there's a portion of the berm along Noisy Creek that staff believes is within the SMA. And we just heard Mr. Van Hattem talk about moving it back 25 feet would do the job. Kernan will move the berm back 25 feet. We also understand that Ms. Rian with CDFW had identified some additional plantings and so forth on that, as the buffer enhancement. Kernan is willing to do that. The item 2C, actually, let's start with item 2A, survey of the property line along Noisy Creek. No, and I believe we already resolved that. We don't need to do that. Item 2C, that's a no. That road has been there since day one, and even before that. It's already been approved in the existing permit. It hasn't been moved. We're not moving it now. And there's no basis to move that. That's item 2A through F, so I think we've covered those points. Item 3 is just simply applying for a building permit for the relocating the berm the 25 feet away. Yes, and I think that's already been, anyway, so yes, that's fine. Item 4, Kernan did not put that asphalt there, categorically. There's no evidence of that, and Kernan says they did not do it, and I believe it. They didn't do it. That said, Kernan would be happy to help remove and do some cleanup there, as just for the good of the property. Of course, the neighboring property owner will have to allow staff onto that site, which we can't control. But Kernan is happy to help get that done. Hours of operation. Now I'm getting to the point of beating a dead horse. You've heard Director Ford say there's no violation here. There Kernan has worked hard to try to modify some of its operations in ways that might address some neighbor concerns without knowing exactly what those concerns are. And those ways are actually getting in the way of being able to get work done during the working season. You heard testimony today to the effect that other businesses that need Kernan services need to get there before 7 a.m. So the way that the existing limitation reads is how it needs to stay. And that allows Kernan to load out vehicles and whatnot outside of the 7 a.m. to 6 p.m., but it will confine its rock crushing activities to that time period. So again, this is the hours of operation. We do not accept this recommended change. This change would be work a significant detriment to this business, and there's just simply no legal basis to do it. So that would be a problem for the county. Number 6, noise. No, absolutely categorically reject this condition. It is, as far as we can tell, there's no basis for it in any permit, the condition that the county has written. It's not grounded in the general plan. It invites people to make up complaints and to do that all over the county. So we're not going to be a part of it. We also know that the only substantial evidence on this issue shows that Kernan is operating within the existing noise condition, which is 60 LDN at the nearest residences. And that is lower than the general plan limit for industrial properties, which is 70. So, no, we will not accept that change, but Kernan will agree to complete installing the quackers on its equipment. They've already made good progress, and they asked for a year from now to get that done. There is significant expense associated with that, but so Kernan will agree to get that done. I think that, let's see, as far as the soil reporting goes, there again, there's no substantial evidence supporting a change to that. If the county wants to see something different, we don't see anything in these recommended conditions. That's a conversation we're willing to have with them, but there's just nothing in these conditions that addresses that at this point, so I don't think action is appropriate. Same with dust. There's been nothing in staff's reports or in the agenda materials regarding dust, so it would not be appropriate to agree to any condition change on that front. Sorry, that was a little more long-winded than I anticipated. I'm happy to ask and answer questions.
That's okay, thank you. Do you want, or I was going to have Director Ford kind of respond a little bit and then come back to you. Is that okay? Yep, okay, Director Ford?
Thank you, Chair Bushnell. So we do agree that removing condition 2A is appropriate. The record of survey is literally on record. I think we can live with the other modifications to accept there is a tight point there where the access road goes in, where some additional buffering would be helpful. Understand not wanting to move the road, but
what kind of buffer? What kind of buffering? I don't understand that.
Neither do I, because I haven't had time to really think about that. I think our original thought was that the road could simply be moved to the west along with the berm. Then that entire berm would be completed all the way down to where the access road goes along the southern edge of the northern yard. I think we can work a solution there to address the road and the berm, and have the berm somehow tie into the road, since there is already a crossing there anyway.
Okay. I think he's got one more thing.
It sounds like we're in agreement on condition 3 and condition 4. It sounds like Kernan has agreed to that. Condition 5, understanding the desire to keep the existing condition. I think with the quackers installed rather than, I think that just putting in the quackers would be suitable for addressing 5 and 6.
Scott, can I ask you a question before I go back to Supervisor Arroyo? How many more pieces of equipment do you have to replace that are used every single day during your hours of service?
At the yard, we've probably done the majority of stuff that never leaves the yard and functions there every day of its life. We probably have a total of 300 pieces or so scattered around.
Okay.
And some of that stuff never comes back. Some of it comes back for maintenance, and it's there for a week and it leaves.
Okay. So could you make an effort, like if the motion were to say in the next 3 months to try to put those quackers on equipment that's in your yard, that you say you see a loader or something, and, oh, we haven't done that one and it's here all the time, and we'll make an effort beyond that year? Was that
Yes.
something you would agree with?
Oh, yeah.
Okay. All right.
That's fine.
Thank you. Okay. So I think Supervisor Arroyo. Director Ford, were you done?
Yep.
Okay.
Thank you. I just had a couple of clarifying questions about that. Thank you for everybody clarifying what's feasible here. So with the buffer, the 2C item, is that an erosion control issue because of the proximity to the stream? Oh, wait. No, it's okay. Is that an erosion? Is the reason you're talking about a buffer erosion control specifically because of stream proximity?
It is related to the stream proximity, and the berm does serve as a erosion control, sediment control measure. So relative to C, we did want to see the berm continued on, which it does right now, down to that southern east-west road. And so really, it's just a matter of trying to somehow now tie that in and keeping as much of the SMA in place as possible.
And do you feel that you can work with the engineers that are working with the property owner on that?
Yes.
Whatever tweak to that design needs to happen, okay, to address that issue. Because I understand relocating the road would be a great expense, and so it seems like that could be a viable compromise. You mentioned the restriction of the rock crushing, but I didn't see in the previous conditions of approval whether that was restricted to certain hours or days. Could you clarify what you mean by that?
That is contained in the operations plan.
Thank you.
Yep.
Okay. So that would stay in place.
Correct.
And then I heard you say that the conversion to the quackers, which I feel silly saying quackers here, but with like the everyday equipment can be done, more in a more expedited fashion, and for all the equipment within 1 year. And then would you be willing to agree to the closure of doors for buildings if maintenance is happening inside? I don't know if there's any reasons why that wouldn't be, like if you're running a diesel engine, you might not want to close the doors, that kind of thing. So are there any reasons why you wouldn't be able to agree to closing the doors?
That's all fine to do that.
Okay.
We need the ability to open the door and come and go, though.
Sure, of course.
So.
Okay, but some of these are volitional things. So some of these I think we're going to outline in these conditions of, revised conditions of approval, and some of it is, I think, making every effort to curtail operations on Sundays and holidays when that's possible, for the good of the neighborhood, and acknowledging that your neighbors are frustrated and making the effort there, but I don't think we're gonna, I also can't really see that we can make a finding about that based on our general plan and everything we've heard today. I just don't, I'm sensitive to the fact that the neighbors are really frustrated about it, and we have to make a legitimate finding, and I'm just not seeing that we can, so I'm appreciating, your willingness here.
Right, I mean, we try not to be there any more than we have to be on the weekends. We're definitely not crushing.
Yeah.
So on, but hey, if 299 slides in or whatever, and we need to go help get it open or send materials, whatever, we need to be able to do that, whether it's 7 days a week, 24 hours a day. If it's got to happen, it's got to happen. It's not just for us, it's for the whole community.
Sure. Thank you. No, I understand. And then when it comes to the berm relocation and all of that, did incorporating the planting recommendations to the degree possible and all of that was copacetic? That sounds good.
I assume you need it on the record, yes.
Okay. Great. Thank you for that. I definitely want to give Steve the opportunity, since this is your district. Do you want to put together a motion, or do you want me to try to go for it here?
Go ahead.
Thank you. Well, I did put a motion together, and I just want to add one more item to the record. It was stated there's no evidence of a nuisance, and a lot of law was quoted there. As I said earlier in my statement, this all started when 24/7 operations began. That's what really started the complaints, the concerns, and the nuisance. And I would add to the record that the evidence of the nuisance is actually validated by Scott Parley's own actions when he recognized that this was going to be such a big impact on the neighborhood that he literally offered people to put them up in hotels away from the site. That's very well documented, and I would suggest to you that that is very strong evidence that he recognized his operations of 24/7 were a nuisance to the neighborhood and took actions to spend money to put people up out of the area. Secondly, many of these neighbors have thought about, well, maybe I should move because it's just getting to be too much. If there's going to be these extended hours of operation, I don't know that I want to live here anymore. And they have been told by real estate agents that their property values have decreased. That is a very well-defined nuisance. So I would just suggest that these things are real, and to downplay them and suggest they aren't real and that these are just a few disgruntled neighbors is not fair. And it's shameful to even suggest otherwise. So, what I've offered up as a motion is what I think is a good compromise to try and allow for these operations. I would even be willing to consider maybe there could be some sort of a condition that allowed for emergency response, as was just mentioned by Scott. Sometimes slides happen, things occur. Occasionally there are situations like the Indianola project that require nighttime operations. I'm just not supportive of allowing that to be a blanket thing, which is what you've suggested. You've suggested that the hours of operation were never included in the permit. I agree that that's been kind of sorted out as, basically true. And what you're suggesting is that there's an unwillingness, not suggesting, you're saying there's an unwillingness to confine the hours to 7 to 6. And that only on the rock crushing, and that otherwise, anytime a contract needs to be taken to work in these extended hours, it's already going to be there and allowed. That's not agreeable with the neighborhood. It's not going to reduce the nuisance factor of these things. Are there situations that come up where there's emergencies or specific cases where one might need to operate in those extended hours? Yes, I absolutely understand that. I'm a contractor. I've hired many of these operators over the years, from Steve Morris to Mackie McCullough to Kernan, to do projects for me. So I get all of that. I'm just trying to find a way forward where we can reduce the impact and the nuisance on the neighborhood while also allowing the operation to continue. So I've put that motion forward, but it didn't get a second. So you guys want to try and craft something, go for it.
Thank you. Director Ford, do you have a motion that you could kind of read to us?
Yes.
Supervisor Bohn.
Well, and backup alarms seem to be the big thing. And then giving them a year to do all the equipment. We're talking 300 pieces of equipment. I'd like to see that narrowed down to equipment that is in the yard 70% of the time or 50% of the time, because they've got equipment that's out in the field. And the equipment out in the field, the guys in the yard are pretty aware that there's equipment are moving all the time. Where we have the issues is the off-highway projects and the highway projects, where you have 4 or 5 contractors working, and they're not necessarily all in sync. And I think they need to hear what's going on. But they're running equipment. I mean, a lot of that equipment runs 95% of the time. The other 5% is running it in and out of the shop. And then on the closing the doors of the shop, if you've ever been in the shop, and I was starting about a little over 40 years ago, if you have the doors open, it's a wind tunnel. So the mechanics, the first thing Steve Lofalt used to do was close the doors because he was freezing. So, I mean, the doors being shut is going to happen. So I think what we're looking at is, I'd like to see it, I don't want to see 300 pieces of equipment with this expense. There's probably, like he said, 30 or 40 that are affected that are in the yard all the time, or whatever they can deem.
Well, this is something he did say was okay, so it's hard to get everything in there. Supervisor Wilson and then Director Ford, if you could kind of outline what we've talked about, that would be great.
Director Ford, I guess I have a kind of a fundamental difference or misunderstanding about with the permit holder on the issue of just because noise, even if we were to say there's no evidence that that noise is an issue, the fact that we have findings on other parts of this permit that are in violation, even without having, that basically allows us the opportunity, and has done so on many permits for other things, to basically, we're at a place where this is a conditional use permit, right? So we have this opportunity to then create and deal with the conditions in the current context. So I'm a little bit, I mean, which is correct here?
That's an important question, and this is an important thing to understand. Because there is a violation and the revocation process is opened up, does not mean that any condition can be added to the permit.
Okay.
It has to be based upon there being evidence of a nuisance that's created by the operation of the facility.
Okay, I appreciate that. So then basically it would have to stand on, what Supervisor Madrone is saying is that he's putting forward that there's evidence of a nuisance based on these things he's put out there in terms of the operator or the license or the permit holder acknowledging that it's been so much of a nuisance that people have been offered to move to hotels and other things. I mean, so also we, as when I say we, I'm just saying the county has made a determination that it is a nuisance, and you feel like we are robust enough in that determination, because obviously the permit holder does not believe that the determination of the county that this is a nuisance stands.
Yes, I'm going to address those individually.
I appreciate that.
Because the period in which Kernan was operating 24 hours a day was a different circumstance than normal operations, where they're trying to start at, say, 6. And I will acknowledge that they really tried to not have their trucks rolling out of the site before 7.
Mm-hmm.
I mean, they've made that effort.
Okay.
And so I think it's different to say that there's a nuisance there because for a 2-week period they offered to buy people hotel rooms.
Okay.
And then you can't really apply that to the day-to-day operation. If that was what they were doing full-time all the time,
okay,
maybe you could make that argument. I think that what we have been struggling with, and certainly what staff has struggled with, is in terms of a nuisance, does the amount of noise that's generated by this site cause people, and I mean, not just, I believe the word was like discomfort, it, in terms of, you know, the legal standard of the state law. It has to be something that has a real visceral response to what's going on. It can't just be something, well, that annoys me. Okay, and so that's where we are constrained in terms of saying that anything's a nuisance. It has to be something that becomes intolerable.
I hear you. Okay, so with that, I mean, from my perspective and from the, you know, in terms of the board, I wanted to go the extra mile to support Supervisor Madrone in his district to get what is needed or what is requested by the neighbors. But I'm having a hard time here, and I hear where he's coming from, and if this was in my district, I would definitely be very concerned about my constituents in that space. I get that, but I'm having a hard time making that the finding, I guess. Yeah. To do it in a very solid way. So I get it. So in the request about just even closing the doors.
Could I? Yeah. Cut to the chase.
Yeah, please do.
Including closing the doors is part of that. And
Yeah.
I can read off what I understand the agreement to be right now.
Okay.
This would move the needle in a very positive direction.
Okay.
It may not get completely there.
Right.
But it improves things greatly.
Okay. Well, I'm willing to listen, and thanks for entertaining my legal jumble there.
So I'm going to have supervisor, you want to move in the spot here? I'm going to have Director Ford read what he believes is the motion, and then next in line is Supervisor Arroyo, and then I'm going to get myself in line, and then we'll go from there.
So as I understand it, the motion would be to adopt the resolution, to make findings to modify the conditional use permit. It would, and with the conditions recommended by staff with the following modifications. Condition number 1 would remain unchanged. In fact, perhaps it would be wise for me to share my screen so everybody can see this. Yep, that's the wrong document. I apologize. Okay, that should be. Yeah. Trying to get it as big as I possibly could. So condition number 1 would remain the same with no changes. Condition number 2 would identify within 90 days of the board action, April 15th, the following things would be occur. And then we'd remove item A, the survey. Item B, removal of the portions of the berm within 25 feet of the outside edge of the riparian drip line. Item C would be modified to say the access road to the lower yard shall transition out of the Noisy Creek streamside management area as quickly as possible. And then the rest of that would remain unchanged.
D, E, and F would be the same?
Yes.
Okay.
Condition 3 would not be modified. Condition 4 would not be modified. Condition 5 and 6, or original 6, would be modified with the equipment operating within the yard at least 50% of the time shall have the conventional backup beepers removed and fitted with OSHA-approved backup alarms that are of a white noise within 12 months of the effective date of this permit. And then I didn't quite finish condition number 7, but the shop doors shall be closed when the shop is being operated at night.
And the number 5? Would be removed, correct?
Yeah.
Oh, yeah, okay.
Yeah.
Okay. And then also, Scott said that he would make an effort before the 1 year for equipment in the yard to have their proper things. Right. Is that on there?
I didn't put the 3 months in there. I can add that.
I mean, you're going to make the effort. He's going to do that.
Okay.
Just a clarification.
Yeah. Okay, so that would be, just 1 second. So that would be the motion if someone, okay, so, and then Supervisor Wilson's going to make a clarification, and then see if we can get this motion.
Yeah, night is not generally a word we use in these types of documents.
What would it be?
It'd be like half hour before, or it'd be an hour before, hour after sunset.
Yeah.
Whatever. Or specific hours. You just, that's a little bit vague.
Yeah.
John, could we just say the shop doors will be closed from 7 during the daylight part of the day
He's doing it.
till?
Right there.
Yeah.
So I'm going to make that motion outlined. Then we're going to go to, if someone wants a second, and then we'll go to Supervisor Arroyo. So we have a motion on the table for discussion.
Thank you. Yeah, I just wanted to note in response to the concerns about erosion control that were brought up, I just was, reviewing the original conditions of approval that are part of item 1 here. And there's a good bit about stockpiling of material, erosion, sediment control, dust control techniques when excavating or storing bare soils to minimize dust problems on adjacent dwellings. So I know that those are some of the complaints that have been raised, but there are terms in there about that. I don't know if you feel that's adequate, but I just appreciated that we're referencing that language in this updated language. And then I also wanted to note, kind of as part of the conversation about noise and being able to make this finding, the general plan EIR language and the general plan itself is just not, it's one of the many implementation measures for a general plan that we need to work on around noise. And so I'll just say that the language is not robust enough, in my opinion, to be able to make this finding, but that doesn't mean that I don't recognize how important that is to people. And it's something that we know, and Director Ford and I have talked about, when these items come up, it makes it really difficult to work on the issue at hand. So I appreciate that there's some willingness to come to the table and work on this. So I'm ready to vote, and I appreciate everyone's time.
Supervisor Wilson.
And then I'm very, again, going back to the lighting, super grateful that Kernan has been, upgrading and being conscious of that because I think it's something, again, very easy to do, very inexpensive to do. It has a big impact on neighbors and neighborhoods all over the place. And so, but I'm wondering, we're having the ordinance that's coming through. Will that ordinance apply to this situation?
Existing lighting, the way the current ordinance is written, existing lighting would be existing non-conforming unless it falls into that nuisance category, such as lighting that shines, and we've got complaints about this. That's why I'm using these as an example. They're so bright, they're shining into people's homes. They can see the shadow on the wall when they walk into the room because their room is completely illuminated by a neighbor's light.
And I would add that, you know, it's also crucial in areas where we have riparian zones. So the critters, the fish, everything that are in those spaces are really sensitive to night lighting. And so whatever we can do to shield that. And so what I'm hearing today is we probably can't put that in a condition here today because it's not one of the complaints, is it?
Well, it is a complaint, but it's been resolved.
Okay.
I mean, the condition is targeted at a certain thing, which is not having the light shine directly off-site.
When you say it's been resolved, though, could the permit holder go back to violating that after we're done with this and then we wouldn't have anything to hold, or would it just be sort of a informal agreement?
They could go back and modify the lights to be in violation again. But then we would start a process of notifying them of the fact that they're not in compliance.
Okay, I appreciate that. Again, just night skies are really important to people who live and want to be in and have preserved their rural lifestyles, and so I think this is really important, and thanks.
So I think just to back on what Supervisor Wilson said, I heard that Kernan was very responsive to the light complaint where they sent someone out there. Yeah, the past teacher, I think, at whatever hours to take care of that. Is that a true statement or not?
I can't say what their internal protocol was. I know that
they were responsive?
They were responsive and modified the lights.
Okay. Could I also have you email that to Kaylee, that motion?
Oh, absolutely.
Okay, and then we're going to call for the vote, but Supervisor Arroyo is going to say one last thing.
I have a comment.
And then Supervisor Madrone.
Thank you. Under the previous conditions of approval under operation restrictions, it says that all new and existing outdoor lighting shall be compatible with the existing setting and directed within the property boundaries. So I think what I'm hearing from Supervisor Wilson, and that I agree with, is that it's not only to be directed within the property boundaries, but compatible with the existing setting to me does indicate that, you know, respecting the kind of rural nature of the area. So I think that covers it, although it's not as specific as we might like, but I appreciate the effort made towards that.
Supervisor Madrone, and then we're going to call for the vote.
Thank you, Chair. I do appreciate the efforts to try and find some compromises and move things forward. But this motion does nothing to deal with the number one reason why we're even here today. And that was after hours, after these operating hours, operations 24/7, and that's still allowed under what you guys are considering approving here. So if you think that's going to resolve this conflict in this neighborhood, it is not. And not only were people offered to be put up in hotels, but the one neighbor that is at Ground Zero, Lynn Owens, literally right there on Noisy Creek across from this yard where all the activity was happening all night long, and it wasn't for 2 weeks, it was for 2 months, if not longer. It went on all the way through late August and in September and into October. So it wasn't 2 weeks. It was a far longer period than that. And she got to the point of almost wanting to commit suicide. And she wrote that down in an email to me. She has now put her property up for sale. She went into massive distress over all this, as well as the rest of the neighborhood that you've gotten complaints from. And those folks have talked often about how it has disrupted their sleep. They have not had any peace. It's not just about the noise during the day. It's noise all night long that was never really considered to be a factor in the operation of this business. It wasn't until suddenly this lower yard started hauling soils all night long that all of this came about. And this motion in front of us does nothing to to impact that. You're basically allowing those kinds of operations to occur without any justification anytime it's determined that it's a contract that Kernan wants to take. Whatever the reason is for that, you're allowing that to basically continue. So I just want to be really clear. I will be voting no, and I don't believe that this motion in front of us deals with, as I've said, the number one reason why we're even here today. And I find that to be just outrageous, frankly, that we're not dealing with this. We're not trying to find a way to really find a compromise for this neighborhood, you know, to bring some peace to them, to allow them to have their sleep and things like that. So that being said.
Okay, I think everyone has, no, she was done. And so I need you to, everybody to make whatever their motion or the vote is, please do it on the keypad.
All right.
Thank you. I want to say thank you to everybody that was here from Kernan, the staff and attorneys and the neighbors. It's never easy to be up here during this time. I hope that, Scott, you heard what the issues are and that we really can try to work for that neighborhood to get them some quietness when it allows and to really move forward. And so thanks. We're going to continue forward. Or Kaylee, go ahead.
Motion carries 4-1.
Thank you. So at this time, we're going to go into closed session, and I'm going to go to County Council and to read in closed session.
Thank you, Chair Bushnell. Yeah.
Okay, are you ready?
I am, thank you. It is the intention of the board to meet in closed session pursuant to California Government Code Sections 54954.5 and 54957 in order to consider the public employee performance evaluations for the positions of the Director of Human Resources, Chief Probation Officer, and Interim County Counsel. It is also the intention of the board to meet in closed session pursuant to California Government Code Section 54956.9D1 in order to discuss existing litigation in the case of Friends of the Eel River versus County of Humboldt et al., Humboldt County Superior Court Case Number CV 2201593.
Thank you. We'll go out to public comment on the Zoom, please.
Thank you. Caller 7718, I will unmute you and you will have 3 minutes.
Well, hopefully you won't be going into closed session regarding the prior topic you did, so congratulations, I believe, hopefully on that one. Regarding Eel River, it's a CV2201. If I understand the numbering, and that goes back to the year 22, I'm kind of curious why that one's still on the board there, if my assumption's correct. I have you're having a reevaluation of 3 different employees there multiple times. I have mentioned one case, and I was explained to another one by your HR directors out there, and I appreciate the communication. For quite a while there, I was told I could not communicate verbally, they would only do it by email form, and that was an interesting one when it comes to avoiding litigation or problems. I appreciate the fact that he told me there were certain constraints that prevented him from investigating a law officer. On the other hand, in concert with and apparently the approval of your interim county council, I was basically, in my opinion, gaslighted from initiating an investigation into the ICWA process. I was told that those documents could not be received, and yet I was informed there's a procedure to get documents that would enable that investigation to go forward. And I just still wish to make that comment regarding sometimes you have to go a little extra, get court permission to investigate something that is necessary to preserve the rights of the indigenous children. So thank you for the opportunity to speak on your closed session. I assume that's about it for the day. I suppose it'll be a while before you report out, and enough rush time in case I decided to stay and listen to how long until you report out. Thank you for the opportunity to speak, and thank you for being there today.
Thank you. That is all, Chair.
Any public comment in the room on closed session? Seeing none, I'll close public comment. Council or CAO, do you have an estimate of time, please?
I would estimate about an hour and a half.
Okay, so we're going to be in recess for an hour and a half to go into closed session. I would like the board to head in that way within the next 5 to 6 minutes. Thanks. Normal. Okay, we're back out of closed session, and we're going to go to County Council for a report out, please.
Thank you, Chair Bushnell. There was no reportable action taken with regard to items K1 through K4.
Okay, thank you. We're going to continue on the rest of our agenda, if I can find it here, and we're going to go to our Clerk of the Board, Tracy D'Amico, to consider changes to the Humboldt County Aviation Advisory Committee. Tracy?
Hi, good afternoon. So before you is an agenda item to discuss the Aviation Advisory Committee. In January, when I brought the list of boards and commissions for you all to review the protocol, there was some feedback about reviewing certain boards and commissions, which I think is very appropriate. And the 3 that we discussed this year were Aviation Advisory, Fish and Game, and Human Rights Commission. So this is the report on the Aviation Advisory Committee. As you can tell, the membership is currently 5 members, 1 each district appointment, and then 4 at-large members. And if you look at the background in the staff report, you can tell that this advisory committee has seen several resolutions which has changed it from time to time. I do want to point out that in this information, all of these resolutions were created prior to the ordinance which came in 2018, which created the aviation department. So when this advisory commission was first installed, it was to help the Public Works Division as far as aviation needs and configurations. There's been a consistent idea and makeup of this board that it would be a representation of certain types of aviation advisory personnel, with some pilots, some tourism, some economic development. Really, it was created at a time that was assisting Public Works and the board. It's changed and evolved a little bit, but at this point, there are some recommendations about making further changes. If you look at the approach that I took in order to present this data to you all, I did attend 2 Aviation Advisory Committee meetings. I did meet with each of the supervisors separately, really focusing on, God bless you, focusing on what the commission membership is and what their focus and strategic plan was. I also had several conversations with the current Aviation Advisory Director, Karen Clower. One of the reasons why this was an important item for us to discuss is that, as you know, you all are looking for hiring a new aviation director. And what we were thinking is if we could get this commission formatted to the way that your board was anticipating or had expected it to be functioning, it would be helpful for that person then to have a functioning board that's working on the behalf of you as the Board of Supervisors prior to this hire. There's, all of you had some different ideas, some similar ideas, but also some different ideas as far as makeup and key focus. There was talk of lowering the amount of membership, about diversification as far as background or specialties for these members. There's been some concern about predominantly private pilots and tenants and perhaps conflict with that. There's suggestions with more focus on economic development, more focus on assets and property as far as how to utilize that as a revenue generator for the department. And then there's some discrepancy in keys of focus, what you all feel that should be the key of focus of this commission. There was an agreement that it should be about economic development, that it should be about destination tourism, and that it should be about development planning and land use strategies. And then there are other ideas about what this commission would be focused on. So really today I'm bringing you information and data, and I'm wanting to hear what your feedback is on those two areas primarily, so that we can update the resolution, because the current resolution is outdated and does need to capture new structure and recommendations from your board. That's a brief summary of this long report. That is what I'm bringing you today.
Thank you. I'd like to give Aviation Interim Director Clower an opportunity if she would like to weigh in, and then we'll go to our board, and if you don't want to, that's fine as well.
Thank you, Chair Bushnell and members of the board. I feel that revising the airport advisory committee is needed. I feel the committee needs direction. I feel that the committee could add value to you as a board and value to the airport overall. I feel the focus needs to be on economic development, destination tourism, primarily over some of the activities that they've recently chosen.
Okay, thank you. I will bring it back to the board. Go ahead,
Can I just add one more
Tracy.
comment?
Sure.
One of the things that we did discover is that the resolutions that were prior to this period have all recommended that they bring an annual report to your board, and I could not find one report from when they were established. And we've talked about that, and I shared that with the commission, or the committee itself, and you know, I don't know if they had the understanding of that. And so that's definitely one area where we're looking to improve, and that I'm also looking for direction for, because there was some comments about once a year, some comments about twice a year, one focusing on the actual statistics from the airports, the other actual work from the commission. So with that being said, there's really 3 areas of discussion and direction that we're looking for. And that's the number of commissioners or committee members as far as makeup for what those should be representing, the charge of the commission, and then what you want their annual or biannual reports to look like.
Thank you. Can I ask a question around, so do you feel if, and I guess this is probably for county council more, so if we change the direction of this committee as it is currently, do we have to disband the committee and then reissue the committee, or how does that look?
No, I believe that you would bring another resolution before the board, which sets the new purpose for the commission at that point.
Okay.
I don't think you would have to disband.
Okay. Okay. Well, I'll just, maybe we'll just could take this, well, just board comments and then maybe take it by item. But Supervisor Wilson.
Here. I would say that before on that list, that the charge is probably more, you do that before you put the committee together or whatever it is, that what the committee makeup is going to be, because that would probably help to derive what that would be. So I would just put that in there. And then there was, for me, one of the questions would be just sort of the administrative, I think one of the reasons why you don't get a report from a committee like this is because there's no administrative support for, it's just a group of people, volunteers. They're not there to put together committees. So unless there was some real connectivity between that and aviation, which has been in flux, obviously, because first it was, we created into its own department, and at this moment we have an interim director who has many other things to do, and so we're in right now where we're putting, we're going to be interviewing for those positions pretty soon here, and so I think we haven't figured that part out yet. In my mind, I almost feel like it would be something that we might want to sort of wait for a new director to come on board and help us with what they think might be, one of their first tasks would be help us create and devise and integrate an advisory committee into this organization based on the needs that we have. So that's just some ideas. I'll just throw that on the table and see where
I just have a comment if I could. I'm going to go to Tracy, but I have a comment about that. I went to some of the meetings, and when I was in the meetings, I felt that, first of all, this is an advisory committee to the board, and I felt that there was probably too much interaction or direction from staff to this board, who should be independent and advise this board of direction. And I feel the exact opposite as you do, Mike, and feel like I, as a board member, would like to get this committee in place and running prior to getting a new aviation committee or aviation director in place, and then to be able to say, after that hire, possibly that board is independent of staff, because that's how it is supposed to be. So I just want to chime in that I feel exact opposite of what you just said, and then I'm going to hand it back.
I was just going to comment and say sort of similar thing, that is a good idea, and that in fact there is the option of disbanding this group, which is supposed to be advisory to the Board of Supervisors. That's not saying there couldn't be an established formation that advises to the aviation department, which would be an entirely different charge. This group was formed because there was no aviation department, and the board was looking for a group of volunteers and people with aviation background to give them the updates on strategic plan, needs, et cetera. So it's really the same, but also different. Like, this advisory commission is supposed to be advising the board and not the aviation department. Does that make sense?
I find that very confusing. I would I'm not hate, but that would be a very weird position for a director to be in, to have a separate organization that advises to the board about what you're supposed to be doing. In general, we don't have that necessarily in other departments.
And while I agree with that, and I'm sure Ms. Clower has something to say about that as well, but it's right now there's a lot of the commission's time that they're spending on operations,
right?
Which really wasn't the design. They were supposed to be more strategic and economic development. So, and I'm sure
And I'll let Karen chime in, but I wanted to say too, when I was there, they were directing staff, and I was like, okay, what's going on here? Because it was very odd, and to see them directing staff and directing the aviation interim director and Kurt, and I just thought, oh, this is weird. And we have Fish and Game Advisory Committee that doesn't sit in with Fish and Wildlife, and then, you know, so we do have those.
But Fish and Wildlife isn't under us.
No, I understand, but we do have those committees out there that do.
Right, but what
yeah.
I'm getting at is this one would be in direct competition or conflict with a director that is under us. And so that is, it's just an awkward.
Well, I'm going to let Karen
construct.
talk because she's been going to all these meetings and she is the director right now. So go ahead.
Yes, thank you. So these meetings, I feel, having attended them for the past, 6 months or so, they're very much about airport operations, and they're not about the bigger picture of developing airport properties. We could use assistance with that. Helping with airline recruitment or destination travel or different projects, rather than the concern of what contracts we're signing or how we're making the decisions that we make. Again, it's very much operational. It acts more as an oversight committee perhaps than an advisory committee. And it does consume a tremendous amount of staff time that could be better focused on running the operations of our airports.
Rex, or Supervisor Bohn, do you have anything? Or Supervisor Arroyo? Supervisor Arroyo?
I mean, I think it's an interesting question about whether, it's a lot to chew on. I hadn't really thought about the structure of it being an advisory committee to the director versus to the Board of Supervisors. I know we have some very motivated, folks who currently serve on this commission and, or committee, excuse me, and but it also, as you acknowledged, it's struggled to get a quorum at times. So I do like the idea of bringing it down to 5 members plus 2 at large. But what the exact, charge that they have is, I agree that they, I'd like to see the new aviation director, which will be in the process of going through that hiring very soon. That individual have a chance to kind of get into their role, but not necessarily have an existing committee, kind of dictating what they want to see with operations while we're also getting to know that person and clarifying our priorities. So I'm open to what you all think. I thought I had a clear idea coming into this, but now this discussion about to whom are they an advisor is an interesting question that I'd like to get a little more clarity around. And maybe we need to take a little bit of time to develop their charge and their purpose. But I'm open to what you all think.
I'm curious if we want to wait until we get a new aviation director and have that kind of dialogue, if we suspend or disband this committee currently and bring back an item after we get an aviation director, and that we have an opportunity as the board to talk with that aviation director and see what their anticipation or expectations would be. And that's kind of where I'm leaning, is to suspend or disband at this time and to bring back a new resolution maybe 3 to 4 months down the road. I'm curious what my board thoughts are, and Ms. D'Amico has a comment.
Well, I was just going to let you know that the timing is kind of important right now. 3 of the at-large members are terming out on June 30th. And so if this was something to be, whichever your decision is, whether it's postponed or suspended, or if it's dissolved and then recreated at a future date, that terming out in the end of June actually works to either of those advantages. Also, if you change the composition to 2 at-large, that would also allow those people to apply for an at-large. to recruit for whatever it is that your board is designating as the appropriate people to be appointed to this commission, et cetera. So as far as timing, that's also working in our favor right now.
Supervisor Wilson.
I hope that we can get to public comment as soon so we can, we'll get to, but I'm aligning with your suggestion, and I have some comments around that.
Okay, so we'll go out to public comment, and we'll go to the Zoom first.
There is none, Chair.
And we'll go to public comment in the room. Anybody in the room want to speak? Close public comment, coming back to the board, and we're going to go back to Supervisor Wilson.
Thanks. And I'm happy to make the motion that we suspend the aviation committee until such time as we get an aviation director. I will say that I think the elements that were brought forward for consideration into reconfiguring that aviation committee is something that I'm in favor of, and I know you talked about 5 members and 2 alternates, but I really want to concentrate on the strategic plan implementation, not just of the airport, but of aviation in general that we already have, from starting with 2017 report and then moving forward. I think is very important. It references all of those things where we talked about in terms of like the operations, the commercial element of this, the tourism element of this, the development and basically real estate end of our operations, but then also what is our long-term strategy for all of our airports? Like, what is the longevity of these assets in these uses, and to reevaluate them. So that my motion is just really just the first part. The last part was just a commentary. So to suspension until such time as we get a aviation director.
I have a question around the motion that hasn't been seconded yet, but I guess from staff, would it be appropriate to maybe get an ad hoc of this board to work with you or work with the aviation director to reform direction for this board?
I was actually just going to ask for some clarity, because this is a very passionate group of volunteers, and to just give them a suspend until further notice is going to be a little bit difficult for them to hear, as well as for staff to relay that message. So either an ad hoc or at least like a direction is like time-wise, like at the end of the year, 6 months under their belt, 2 months under their belt, just and maybe an ad hoc. I mean, that's a board decision and definitely a conversation, but something that we can share about how this process is going and when they might expect to hear something from it.
Karen?
Other airports do have committees as well. So a new aviation director could come in with some, like you've said, some of their own ideas that might be more beneficial. And then regroup with the committee, whether it's as it stands or as an ad hoc, I think would be beneficial to develop their new charge going forward.
And so the conversation, Mike, I'm sorry you didn't get a second, but yeah, so I'm just curious, because I do think that at this time it is appropriate to maybe suspend it for, to get the new aviation director in, have this board create an ad hoc right now, and then to work with, going forward, and to give the message that very temporary until we can get some better direction. So you're going to get like a little reprieve for a few months, and then we'll reconvene the board. And I want to ask, I guess, council, if we suspend the committee currently, when we reinstate, it would have the same members on it. Is that correct?
Yeah, we can draft the resolution to, or whatever documents we do to suspend the committee, to state that.
Okay. I'm going to go here, and then I'll come here.
Why are we suspending it? I'm just, do we think they're going to do something drastic in the next 2 meetings?
Well,
they might have something that they need to discuss. We have an airport director. I'm just saying, we can regroup after we get a new airport director.
My interpretation of why we would is that there isn't a direction for that board right now, and that they're working outside of the, what is the thing called? The charter, and so trying to, that's what I read in the staff report is there isn't a direction for them. I've been here 5 years. They've never came and made a report to this board since I've been here. How about you? You've been here the longest. Not in the last 5 years.
Huh?
They've never came to this board since I've been here.
Well, and that's.
It's not their fault. They don't
No,
have
I
a
know
direction.
it's not their fault.
Right,
I'm trying to remember when Fishing Game did one, but I just.
2 weeks ago.
You know,
2 weeks ago.
But what
yeah.
I'm saying is all. So they have no, so they've had no direction, but now all of a sudden we've got to cut it off for the next. They might have things they want to discuss. They might think they have direction. Has anybody asked them?
Yeah, well, I just will respond that it's very hard for staff, and it's very hard for the Tracy, actually, who does that, when she's trying to help them, and there's not that direction there.
And I fully support where Tracy's coming from, and I know what she has to go through. I'm just saying, the optics on this is, okay, you guys are done until we figure out what we're going to do with you. It makes it sound like they haven't done anything. That's just.
I think Tracy wants to respond.
Well, I was just going to say that it was your direction to bring this information back. And so, you know, there are options, and we could continue and look at membership, et cetera. My intention wasn't to come and suspend it, but I was told to bring this back in a timely manner prior to the aviation director being hired so that we could hopefully get them on track. So that is why we have this today.
Supervisor Arroyo?
Yeah, thanks. Well, I agree that an ad hoc could be helpful here to meet with the members of the committee, or perhaps they could, we could work out that process, but to, you know, and the new director to kind of help shape that into the most productive use of everyone's time. They are a passionate group, and I by no means want to quell that passion that they have for aviation. But I, like my colleagues here, I think, you know, we need a little bit more clarity around it. I am concerned that only three people's terms go through June of 2027 of the list we have here. Most of them were appointed with a term that ends June 30th, 2025. So if we were even to do a short-term suspension of like 3 months or something, by the time we came back, most of their terms would have expired. So we'd be in the position of seeing if they'd like to be reappointed or soliciting new applicants. That's not the end of the world, but I would hate for it to kind of feel like their contributions weren't appreciated if it sort of fizzles out and they don't even have one last meeting for us to express appreciation for them and all that. So something to consider. I don't know that I'm attached to the suspension as much as, you know, retooling this and having an ad hoc and some advice around how we make this as useful as possible in conjunction with the hiring of our new director. So just wanted to note that about those. The terms are staggered in a funny way where there's 1, 2, 3. There's like 6 people whose terms end June 30th, 2025.
Tracy?
I was just going to say that they are scheduled to have a meeting next Tuesday, and that agenda's already been reviewed and published. Suspending them prior to that might be hazardous. It might be something that we could add if whatever you decide tonight. That I had planned on speaking with them in May about what was going to unfold today, but we can always change that. And then I also absolutely want to take responsibility that this committee was created prior to my coming here, but part of our responsibility is to look at these boards and commissions, and we have not done the greatest job on that because there are definitely things that are a bigger priority. This is part of that process of improvement for our department and for all of process overall. And I'm very much aware that they have not had a lot of structure and guidance, and I apologize for that. And we are definitely working with them and the other commissions now that we have more staff and a better idea of what the board is requiring. So they are the first one that we're reviewing. Our intention is to go through all of your boards and commissions so that we are focused and functioning and very much committed to a process and a procedure so that all of them are running smoothly. So I just wanted to put that out there.
Karen?
And I just want to restate again that I feel an advisory committee could add value to aviation, to the board, to even the new department head. Currently the group is very passionate about aviation, and I greatly appreciate that. However, I just really would like to see them have a direction and less being in the weeds, so to say, of day-to-day operations of the airport.
Thank you. I guess I would, first of all, like to, I think an ad hoc would be really appropriate. And so I would move that we do form an ad hoc with the members, some members of, two members of this board, and that we do talk about, I would like to, you know, obviously they're having a meeting next Tuesday, so it would be appropriate to go and speak with them, but to maybe pause them for a month or two while we hire a new aviation director, and that would take them almost into June. I mean, if we want to talk about lowering the amount of people on the advisory committee, we can do that now as well. Direction to come back. I think 5 appointed members from this board and 2 at large is sufficient. I don't know how my board feels about that. Karen would like to say something real quick.
I think the makeup or the number of committee members could depend on what their focus becomes. So perhaps reducing the number now might not be beneficial.
It could come back, yeah.
That's just my thoughts.
Tracy?
I was also going to say that part of what I was planning on helping them with after this discussion is to creating a bylaw, right? So that is also something that an ad hoc would be helpful on, because once that charge is captured, that is the committee focus. And they have not had that up to this point. They've been working off resolutions which have not been updated since aviation department was created. I think that my suggestion would be that having the meeting in April and then suspending until maybe August, which would give an ad hoc enough time to give us at least a starting point to look at the membership, drafting bylaws, and moving it forward that way. So.
Yeah, I'm gonna make that motion, that we suspend, is that what we're doing? Suspend after this April meeting, which none of us, I mean, if any of us who are going to Sacramento, I think on that day, so, yeah, it's Tuesday, so, it's unlikely that any member here will be there for that, but, that's okay. It is what it is.
Not if we create an ad hoc. We kind of need to be there.
Well, if we create an ad hoc, we can have a scheduled meeting later. It's all right. We can reschedule that meeting for another time. It's till between now and August.
Yeah.
So maybe if that committee wants to meet in April or on Tuesday, that's fine. But if there's an ad hoc of this board that's not going to be there, and we want to schedule another time to meet with that group as an official meeting or just as a group, that's fine. We can do that between now and August. More importantly, what we really do need to meet with is the new aviation director. And so I think we should just get that started. I mean, more important than the makeup, again, is really the charge of the committee, and really whether it's a committee or a commission even. I mean, I'm feeling like if it's going to have if we're going to really give some empowerment, then we might want to really reconsider how we we look at it, and then that we'll have to generate again the funding for that administration as well. So the motion is to suspend this committee after this April meeting, and then create an ad hoc to move forward.
I'm a little concerned about not having representation at the meeting on Tuesday night.
Okay.
To share not just this information, but as you know, Supervisor Bushnell, who's attended, they're going to have some questions and concern. And so my idea was to come in May to share this conversation and also have a supervisor there so that they could help explain and deflect. But what we can do is have the meeting on Tuesday, suggest that they have a special meeting
Yes.
2 weeks later to just have the topic of Board of Supervisors recommendations and discussion on moving forward. That would be the last meeting, then codifying the suspension, sharing the information. So Tuesday would be a regular meeting for them. We'd schedule a special meeting then to go over what was discussed today, bring it to them with possibly a board member attending as well, and letting them know where we're moving on from there.
And I'm going to suggest for the ad hoc committee that I'm just going to put this out that one of the two of the facilities committee members be present for that, because we really are talking about strategic planning for facilities, and it's going to be important that we're engaged in that moving forward, and we don't want to have things kind of bouncing back and forth in sort of some odd ways. So
Can I suggest an amendment to your motion?
Sure.
Can we amend to, we will suspend effective last day of this month, April, so that they can do the meeting on Tuesday, and then in 2 weeks we can have a meeting, and that we create the ad hoc right now, which would be comprised of 2 members of this board, and that both of those members of the ad hoc go to that meeting. So if you are going to suggest facilities, someone from the facilities, that's going to be you two. So one of you all need to pick, and then one of us needs to be the other person. So I think that the ad hoc wants to go together. Well, I think my motion, well, you never got a second, so I'm going to make a
I'll make a motion that the committee is comprised of myself and Supervisor Bushnell.
Or I think Supervisor Bohn might want to do this one.
Okay, that's fine.
Okay. Okay, and to suspend at the end of April.
Got it.
And then to have a special meeting 2 weeks prior to this meeting coming Tuesday so that we can discuss with them.
Did that already get a second? I'm having a hard time keeping track.
I'm in a second.
It's pretty bouncy.
I love
it's
it.
Pretty bouncy.
Can I just reiterate the appreciation for the Aviation Advisory Committee members? I really hope that we're able to convey to them adequately that, especially those who are terming out, and if we change the structure, may not be reappointed down the line. I do want to make sure I know we'll do certificates of appreciation and everything, but I just want to make sure that they feel that this isn't punitive, that it's just about getting more clarification so they can be as effective as possible.
I don't feel it's a reflection at all on the members. They are so passionate. Their intent is to help. Like, you can see it all over them and in the discussions. I don't feel that that's a reflective direction of this at all. It's just that we want to give them more direction to be able to be helpful. I want to be advised by them if that's the intent, so that we know what we're doing too. It'd be so helpful to our board. I think Tracy wanted to say something. No?
Yeah, ditto. I mean, anything that their ability to be effectual is on us, and so that has that direction has not been, and not just direction, but also administrative support too. It's like just now they're getting administrative support for such a long time, and so this has been difficult.
So I don't think that's true. I think that the aviation staff has been very interactive with them and has done so much for them from what I've discussed with the aviation staff. And in fact, Cody used to run their meetings. And so I think that they've had a lot of support from the aviation staff. It's just not a lot of direction what to do with their thoughts and ideas. Karen?
I would agree with that. The Department of Aviation, their admin staff has really supported the committee through the years, to the point they were the minute takers up until the last few months. And they set up the Zoom and till just again like the last few months. So they've been extremely supportive of the committee.
And this is the reason why we're deep diving into these boards and commissions, because the realization that this resolution hasn't been updated in 15 years is a flaw on process, and we are here to improve that.
And I appreciate you taking responsibility, Tracy, but also this board. I've been here 5 years and I've never asked why they haven't came to advise us. So it's on our board as well. I'll just say it's on me as well. I didn't say, how come they're not doing that or whatever. Supervisor Bohn?
I think it's not a breakdown on anybody's part, because I specifically, every time Cody or anybody came to us from the airport, the advisory committee was here and reported and spoke at length about a lot of stuff. So it wasn't the fact that they came all by themselves, but I mean, I can remember seeing them out there.
Because they're pilots, so they're here.
Chair, can I repeat the motion and get confirmation, please?
Supervisor Wilson?
I've forgotten that I even made the motion,
Can
so
I-
here we go.
Can I read it and just get
Go
confirmation?
ahead and read it, yep.
Thank you. So suspend after the last day of April and schedule a special meeting 2 weeks from Tuesday and form an ad hoc until August 2025.
Did you get the members of the ad hoc on there?
I did not. Can you?
Bushnell, Wilson?
Of Bushnell, Wilson. Gotcha. Thank you.
Thank you. Motion maker, does that sound right?
Sounds good enough for me. Yep. Is there a second?
I already did.
Okay,
Second,
great.
correct.
Oh, we have it up here.
Motion carries 3-1 and absent 1.
Thank you.
Thank you.
Okay, we're going to go to our last item of the day, which is coming to us. Let me get my agenda up, please. From ECDev. And the internet timed out. Project Trellis Local Equity Program Update and Community Equity Grant Award. And we're going to go to Peggy. Hi, Peggy.
Thank you, Chair Bushnell. Good afternoon, Board. My name is Peggy Murphy. I'm the Interim Program Manager for the Office of Economic Development. I have with me today Economic Development Coordinator Ryan Heitz, who's going to be providing your board with a brief presentation on the Project Trellis Equity Efficacy Report provided in your agenda's attachments, after which Ryan and I will be available to support your discussion and answer any questions you may have. Thank you.
Good afternoon. Thank you all for your time today. So as indicated on this report, we have provided some of this numbers previously. Equity 2, Equity 1, the Emergency Grant Fund, and the Micro Grant Round were all previously reported on. So on the second page of this, it's really focused on Equity Rounds 3 and 4, which were actually composed of 4 separate fiscal years of grant funding through the Community Equity Grants Program by GoBiz. So in the last couple of rounds, we've had some 433 applications, of which 132 have been funded to date. We've expended almost all of the funds. As you may see on the second page, the $5,889,000 is a little bit short of what was reported on the first page in total funding. That is a result of some of the funding still being outstanding, as we haven't received it from the state, and our budget is pretty tight, so we'll be releasing that targeting July 1st. To get those funds out to the community. We do have a queue established based on the most recent round. as you may recall, between Equity 3 and 4, we had to come back with some modifications to the local equity program manual at the behest of the state in order to accept that funding that was part of that award. So I've tried to get as much information on here as possible, breaking down the amount of funding that went out to the different districts and highlighting all of the different sources of use of these funds, spread across not only the 12 service items described in the local equity program manual, but also the Measure S, property taxes, and planning and building fees, which were added most recently.
Thank you. Questions?
Well, where do we go from here? My question. How much funding did we get this year then? What's the latest round?
The most recent round is the $657,000. We applied for 600 and were awarded 657. I believe there was a little bit of overage.
Okay. And our investment in that is?
There's a $100,000 match requirement. There's now a one-to-one match requirement for any funding applied for over $500,000. Unfortunately, the administrative cost of this is quite high, given the amount of work that's necessary to review applications, contract, and then monitor over the period of time. So the $50,000 that would have been available in a $500,000 grant would not have been sufficient to cover staff time, let alone beyond the period of releasing those funds and monitoring them.
So what are we estimating for the staff costs of this then?
Right now, we've got 10% of the total state funds allocated, as well as the $100,000, with the remaining funds we have from the prior round, which was $600,000, with another $100,000 of the annual contribution we're getting. We do have a little bit of overage. We have to figure out if we can stretch that administrative funding into some grants, perhaps, but it's most likely that it's going to be necessary to run that for administrative costs through next year.
Wait, how much total? Not percentage-wise, like what's the number?
The total
200 and something?
It's...
It would be like 280?
We don't have 280 yet. It's I think almost 200. We're just shy. And we still haven't been billed for any of the central services that are going to be required as far as council and everything for the last couple rounds.
So we're expecting to spend $600,000. We're gonna, to let $600,000 in grants. We're gonna spend 100 plus
probably about 150,000 out of the total amount of.
The total amount. Yeah. Okay, and then then there's still other administrative costs that haven't been accounted for as well.
Yes.
So the total administrative cost is even beyond that 150,000. So you're just like,
and it's difficult to calculate because we have the current award we have to release by October 31st of this year. So between July 1st and October, we'll be working a contract and release those funds. After that October 31st deadline, there's no ability for us to expend any of the state's funding on the administration of the program.
Okay.
And part of that is the delays that were caused by the holdup of the state on forcing us to
So then in order to
come back.
expend those, we would not be able to recoup our administrative costs in the expenditure of that.
Yes.
So that would be another cost to us, whether it's 10%, 15%, 20%, we don't even know.
Yeah, with this other award pending, there is an opportunity for us to really focus on getting all of the money between these two rounds out in July and take a little bit of advantage of the sunk cost that's already been committed as far as review. And
so from my perspective, it sounds like we have several pots of money that we're looking at. Some is Measure S money to, helping people pay off Measure S, and then another one is for fees, another one's even for property taxes, and then it gets into other sort of capital cost programmatic stuff.
It's not split up like that in the LEP. It's prioritized first come, first serve, so the queue is established, and then of those individuals, we first pay Measure S taxes that are outstanding, then property taxes, then planning and building fees, and then any remaining funds go to direct grants to the individuals.
Can I add that this was at the board's direction last time, Mike? The board directed how to, and it's today, provide direction to staff on the continued implications of the project trellis, right?
Yeah.
So this was how our board directed a year ago, was to Measure S, property tax, past due, so forth and so on. And so we do with a new amounts, we could change direction. That's part of the discussion today. Is that correct?
Yeah, you absolutely have the
That's what I'm getting
opportunity
to.
Yeah.
That's what I'm driving at. That's
Okay.
what I'm trying to just suss the kind of current conditions and then make an assessment from sort of the success and challenges of that to, you know, steering in a more sort of efficient and successful way. So could we basically say, it seems like the most effective way we're getting money out is Measure S reimbursements. Like, does that seem like the
It's
in terms
definitely
of
the,
like an
the
administrative
lowest administrative burden
Right.
for staff, and it's a pretty simple process as far as communicating with the Treasury Tax Collector's Office and identifying what the current obligations are, and a single journal to.
So like one option could be like, with the rest of the money that hasn't been allocated already, we could say like, this is just just a Measure S monies, and
Yeah.
anyone who is applying for Measure S reimbursements, this is what we could do.
My preference would be to use the established queue, because we are working on that first come,
Right,
first
right,
serve.
within the established
yeah,
queue.
I think if we did just Measure S, it's just shy of 40 individuals that we could spread the funding across.
Okay. Well, that, I mean, to me, this is becoming less of a effectual and impactful program. And the most impactful part, it seems to me, is just getting people, helping them with their Measure S and their tax money and those other things, which turns out is more effectual for this institution.
Mm-hmm.
The hardest part for this, and what we keep seeing, at least what I keep observing, is like the more complicated the project in terms of like whether it's like solar systems or culverts or all these other things, I almost feel like we have a very small staff, and the administration and auditing of those processes is pretty burdensome, and should probably be. And if I was in another time and place, I'd probably say like a third-party nonprofit could probably do that work better than our staff, who are economic development staff. They're not rural development staff. And so, so from my perspective, like, that's where I think we should be focusing our energies, is in that space with the limited amount of money that we have, because we don't have a lot left necessarily. And as far as I can tell, and the way I read the state's literature, it looks like they're going to be reducing monies to Humboldt County in the future.
Yeah,
What do you
the
think?
program modifications have not been beneficial to Humboldt County. Peggy highlighted recently that the most recent award actually sees almost double the amount that we're receiving for the County of Nevada, which has 34,000 people in the whole county. And the reason for that is the county was able to apply, as well as the city itself. None of our municipalities engaged in the LEP process, which would have made them eligible for applying individually. So at this point, the county is the only agency, and then has that 500,000 cap on it. So.
I see. Thank you.
Do you want to talk? Do you want to? So I just, continuing to pay back due Measure S taxes, or that be the qualifier at this time, really cuts out the people that have done all their things. And like, there are over 1,000 permittees that have compliance agreements that still might need just a little bit to get over the finish line, have paid their Measure S, have paid their planning and building fees. And so cut me off if I'm wrong, but what Supervisor Wilson is saying, let's go ahead and pay the rest of the back due Measure S and not qualify people that have done their Measure S and done their efforts and really are trying to continue forward, but maybe have just a little bit they need to get over with their compliance, such as rain catchment, a tank, or a solar system. And so I disagree with the analogy that we just make it for back due property taxes or back due Measure S at this time. And I do want to say that that we need to be very involved with the planning and building department. I know that you all are, but there are a lot of farms dropping right now with this new growing season starting current. They either don't have their state license, they've followed their state license, they don't have their county license, but have their state license. And so it's a pretty tricky situation right now with cultivators. Just my 10 cents on.
If the funding was still at the levels it was in previous years, I think that it would behoove us to continue on as we were. With the limited amount of administrative funding, it's going to continue to be more burdensome to review all of the expenditures that these folks are using these funds for. We have a lot of modifications to these contracts coming in throughout the year or so that they're given. It's really ultimately, as far as I see it, there's no great solution that's going to provide an equitable result for everyone. The first come, first served nature of this program has made it very difficult, and ultimately people are just rushing in to get these applications submitted as quickly as possible. And I think 40 or 50 of them out of the last group of applicants were denied just because their documents were completely lacking, and it was obviously just a quick, I got it in over the line, but incomplete.
Well, we do have new Measure S taxes that are coming out, I think, in 2 weeks, and those are not past due, they're current. And so maybe that's a qualifier that could open the field to everyone again, even folks that, because everybody's going to owe that Measure S again, 10% for last year. And so that could reward folks that have really worked hard to keep all of their bills current. I don't know. It just feels weird to me.
I like the idea of trying to spread the funds equitably amongst everyone, and making it prioritized on Measure S would still reduce the administrative burden of having to go through and review all of these expenditures, because if we are just sending it over to Treasurer Tax Collector, we've indicated how the funds are being spent. We can submit our final report half a year in advance. I don't know if we have an easy way to calculate a way to distribute those funds equitably amongst the people who are in queue, because everyone is such a unique individual as far as how their operations go. They're different scale, they're in different situations, some are fallow, some are not. So it's a very challenging program to manage and provide equitable service, because no two individuals are alike, really.
But we could say that it goes for current Measure S coming up.
Yeah.
Which is the 10% of last year's cultivation.
Yeah.
And that would be really equitable across the board for everyone.
Yeah.
I like that idea better, because it opens it up for folks that have already paid their Measure S, I just like that better. And I believe those bills are coming out in around 2 weeks.
I think we would need to clarify whether or not we are paying the back taxes first, or only those for individuals who have current Measure S as well.
I mean, I would consider current Measure S, not back taxes, because it is equitable to everyone that has already paid their Measure S and gives them that opportunity to apply.
Mm-hmm.
I guess if someone qualifies that has back taxes, maybe it could be either or for them. But I think for the tax treasurer, it would be amazing for them to get the current Measure S is going to be comes out in 2 weeks and is due in 30 days. So it's going to be a burden for folks, again, with the cultivation season just starting.
I would clarify that we are hoping to not open another application round, because we do have that queue, and so this can be applied, of course, to the current queue. The administrative burden of running another application round is significant.
I would ask does that current queue, it didn't include people that didn't mow Measure S for last time, right? Because
I'm sorry, can you clarify?
so people that applied were people that owed back taxes, or what? Go ahead.
No. It was a mix. At the initial application time, we still had the rule in place that you had to have a payment plan in place prior to being eligible. That's no longer the case, but we haven't gone through and reevaluated all of those. There's probably only a couple, if any, that were actually eliminated from that process due to the Measure S payment
You're not
plans.
understanding what I said. I'm asking the people that applied, because we set the qualifications for application back to taxes, back to property tax. So the people that didn't have any of those past dues did not even apply.
Sorry, those were not eligibility criteria. That was the preference of the board to actually pay those obligations first. The eligibility criteria were separate.
Okay, that's what I was asking. Thank you.
Yeah, we sound somewhat aligned on that. And but then there's the question of whether or not to reapply again for this program. And I'm having some doubts about whether or not. It seems like we're going to be limited. It seems like the administration is becoming overly burdensome. I mean, I get it where there's maybe just one, water tank, or one this or one that, but it's just, you're right, when the applications are tending to come in incomplete, or then there's the request to go for completion, and then there's just administering that for smaller amounts. Like the cost ratio burden for those is just becoming really high, and certainly beyond 10%. And so not only are we paying up front for the $100,000 just to engage, that now we're definitely burdened by the administration beyond beyond what is allowable for reimbursement from the state. So I'm just going to say, like, it's not looking like a very cost-effective program for us. I'm sure we are going to hear differently in public comment, which should come up soon, I guess. So those are some considerations.
Yeah, I'll go out to public comment, and we'll go to Zoom first.
Thank you, Chair. Caller 6228, I will unmute you and you will have 3 minutes.
Hello, good afternoon, Supervisors. Natalie DeLapp, Humboldt County Growers Alliance. Can you hear me?
Yes.
Okay, good. Okay, so first off, I want to give a huge shout out and thank you to Ryan Heights and Peggy Murphy, who have been navigating these GoBiz funds from the state for the last several years. And I just want to acknowledge that these are super complicated grants to administer, and that the state is absolutely not giving enough funding to administer these complicated systems, and then they go back and audit, and I know it's a total pain in the butt. But that being said, these are the only types of funds that come in that can be accessed by our people, which are cannabis operators. We don't have access to the traditional type of grant making that is available to other small businesses. So these types, and specifically this grant, is very, very important. I really encourage you, and to Supervisor Wilson, I know that this stuff is getting to be challenging to administer, but I really want to encourage you to stay the course and maintain these equity processes administered, and relying on getting these funds from the state and bringing it into the county. And so please, that's point one. To the point of, there is an existing queue. People applied for these grants back in like the spring or early summer last year. There's probably more than 50 people in that queue, and they may have applied for $35,000 for any number of things, and then you guys gave direction to pay off these back taxes. So, please stay the course. Don't delete the queue, because that's going to be even more complicated. What else was I going to say? I just lost my train of thought. I'm so sorry. There is this opportunity. So it's like, I really trust that Ryan and Peggy can make this process as efficient as possible. Don't tell them to change direction. Deal with the queue, pay off these taxes, and to Supervisor Bushnell, the people who are in the queue may have been people who never received any funding for anything else. So this is providing resources to pay off any number of very important and vital business expenses that they need to be functional businesses. So I apologize for being a little discombobulated. Thank you for my time.
Thank you. That is all, Chair.
Thank you. Public comment in the room. Seeing none, I will close public comment and bring it back to the board.
It seemed like we had some alignment on this, and so I think it'd be best to maybe if we could craft a motion to kind of move that forward. Ryan, you want to help me out here? Because the language of this is a little bit awkward for me. Can you capture what you think you heard, and then we'll see how we go with that?
Yeah, so I think what might be popular now is that if we modify the local equity program manual to remove the other expenditure lines, which is the 12 service items that were set by the board, as well as the property taxes and planning and building fees, and exclusively pay for Measure S, I think we would need to establish that's current for whatever established period of time, and then we can pretty quickly work through the list of applicants and get those funds out.
Okay, and then what about direction in terms of the future? Do we, say that we're not going to apply for these funds again, or do we say we will consider it late? Is it something we should and can maybe consider later, or is it something we need to really kind of take a decision about now? And when is that next round going to be?
If we were to consider it later, we would likely need to ask for more general fund admin money from your board. The application period falls outside of the grant terms, as
Right.
does the final reporting period. The other thing to keep in mind if we continue to reapply for funds is that to get through what remains of the queue, we need more than 4 years. And so if you consider someone who's in dire straits right now, making it 4 years out, it's not the most positive outlook.
Right.
The other concern is there is an administrative burden to every time we receive funding, ensuring that someone is still eligible for those funds.
I see.
And I would just add quickly the clarification on whether or not you want to fund those individuals who do still have outstanding Measure S taxes that are past due, or to only prioritize those who are current and to pay their current bill.
Okay, so now what we want to do is put that in a language that Kelsey can administer for us. So let's take a shot at that. Kaylee, sorry.
I was all
Sorry.
Kelsey.
Sorry. Sorry. It wouldn't be the first time.
So
either.
I do, if you're going to make a stab at that, we have to authorize so staff recommendations, right? Authorize the county administrator to accept the CEG for fiscal year 24-25.
Thank you.
Needs to be in there.
Yes. Okay. You ready to help me with this?
Sure.
Okay.
So my recommendation would be to accept the CEG award for the most recent round of funding and to direct staff to modify the local equity program manual, removing all service items but the Measure S taxes, and to specify whether or not you are only looking at those individuals who are current and are paying for a current bill.
Did you get all that?
Peggy might have a better shot.
Yes, I did.
Okay, great. That's my motion.
And so we're not going to apply for further funds, or?
What is that the first part of that? Is that what I'm missing in terms of
Receive project
the staff
trellis.
recommendation?
That's a report.
Sure, yes, and that too. Sorry, let me get back to that part here. Hold on. I'm getting into
As
the
Peggy
staff
mentioned, we could bring that up at a future date. It would require some further costs that I don't think we have funding for. So if your board did choose to direct us to bring something back, it would be difficult for us to do so within the current funding.
We should include that now, correct? We need to include it now.
To include give direction that it will come back as a
No.
proposal?
That we will apply for future grants.
I think that should be discretionary at the time, because if we don't know the cost of that, why would we do it? I mean, that seems
So the grant, I will say that the grant does cover those costs, and it comes from Peggy, can you explain?
So the grant does cover those costs. The
Yeah.
problem is the grant term ends on October 31st. The grant application itself does not typically open till November. And then there is unfunded costs, of course, for supplying, staff time for bringing those items back to your board for approval and acceptance. And so there is that issue with funding. So further funds would need to be made available, in part because the matching funds provided by your board have to be utilized in that grant term as well.
And we don't, do we know what the cap is going to be on that for us now? Or is that still 500,000?
It's expected to be 500,000 with a $3 million cap. If you did want to match it, $3 million and swing for the fence.
I'm gonna have Supervisor Bohn has a question.
So, and staff has time to do this, don't they?
To apply for the?
Yeah.
I mean, we would get it done if necessary, but it's.
What is, okay, thanks.
That's not what he's asking, Ryan. He's asking that if we direct board you to apply for the funds, then is it going to be a huge burden, or?
Not a huge burden. The application process is relatively straightforward, but again, it's the question of whether or not we're going to be contributing matching funds. Preferably, we'd make that decision now. Otherwise, we'd have to bring it back at a future date and determine it then.
And to speak to staff capacity, all members of the economic development team run multiple programs. And so it's maybe 15 to 20% of Ryan and Nick's time, which does have some capacity issues depending on time of year.
I'm going to ask the CAO Hayes chime in.
Yeah, I just want to prep your board that if you would like us to continue applying for these funds, that it is very likely we will come to you and ask for a general fund allocation of more like 150,000 than 100,000, because what we're really trying to stress here is that the administrative function is falling into other funding sources. Other grants can't pay for this, which only leaves the general fund. And administering this program has caused strain on the economic development fund overall. We're trying to rectify that fund balance so that it is not going negative, which means it's going to fall on the burden will fall on the general fund to pick up that difference. So I just want you to be aware that to expect, if we are going to continue to manage this program, that additional general funds will be needed.
So you get 500,000, you have to match it out of general fund 100,000, is that correct?
To get it up to 600,000.
Okay, and then you're saying that we have to put another 50,000 out of general fund? Why wouldn't it come out of the grant?
Because the grant only allows a certain percentage to be used for admin, and because you can only reimburse for that admin during the grant period. There's an initial ramp up where we need to take applications, we need to review those applications and determine eligibility, and then there's a further follow-up at the end of the grant term where we need to ensure that the funds are being spent appropriately and reported on appropriately.
I'm not done.
That falls outside of the shorter grant window in which we can use those funds for admins.
Is there an opportunity to ask the state for extensions on that grant window so that we can utilize those funds from the grant and not have to use out of general fund? Grant management.
I don't think so.
You don't know, or you don't think so? I mean, could we?
Their preference has been to push pretty hard on no extensions on any municipality or jurisdiction. It's possible, but it's unlikely that we would get them to extend the period of our expenditure, but it's much more likely that we would get them to give us some extra time unfunded to provide all of the final reports.
So the thing is that if we don't apply for this, then any kind of trellis is done for Humboldt County.
We're at a point right now where that is the case. With these two grant rounds, with the partially funded one and then the one that we're potentially accepting today, we can reduce our staff time a little bit and get a lot of those grants out, which will give us time, at least for this new award, to report within the period of performance so we can bill all of our time there. The funds that we're releasing now by the October 31st deadline of this year, we're going to be spent down and have no funding left from that pool of funds to continue the reporting afterwards. So,
Supervisor Arroyo.
Thank you. I understand what you're saying about the administrative burden, and it's a little bit of a unique situation because if we change the criteria to be solely applicable to Measure S fund, Measure S unpaid taxes, then, obviously that's a benefit to the county. And I heard that would be administratively much less difficult. So do you have thoughts about how we could sort of continue to keep that cycle rolling with less of an administrative burden, and also, it's obviously a benefit to the community, but it is also a benefit to us to structure it in this different way. Do you have any thoughts about how to approach that?
Without knowing specifically what we're going to be funding, because again, if we're not paying those individuals who have back taxes, we're only paying those people who are current and only paying for a current fiscal year. I don't have any of that data, so I don't know how much time it's going to take to draw that together. But I want to agree with CAO Hayes that even if we did just apply for the $500,000 and that left us $50,000 during the period of performance to release these funds, there would be additional burden that would fall on the general fund outside of that to report.
Yeah, and just quick question.
Hold on, Supervisor Bohn was next. Supervisor Bohn.
So why is it costing so much to administer?
If I
And,
could-
and what I worry about, what I'm worried about, if we're not going to do trellis, are you facing, because you said it was 20%, are we facing layoffs in your department if we're not going to do trellis? Because we're not going to have, because we're looking at 25, well, above 30% administration costs. If we're looking at over 100, 150,000, 600 is 25, but you're talking plus, and I'm just, that seems like an awful lot of administrative costs. And then the other factor is that some of these funds will not have to be administered because I've already had enough phone calls that if they don't get their money by this season, they're done anyway. So, and you guys have had those same phone calls and they've heard the same thing. We don't have enough time. We can't do it, yada, yada, and yada. And that doesn't bode well for them. It's okay for us. You guys, we're all still getting paid, but.
Reevaluating the individuals in the queue in July, I don't think is going to be too problematic. Reevaluating that same queue following the end of the season is going to be difficult because we are going to see a lot of folks falling out.
CAO Hayes?
To Supervisor Bohn's point, that's exactly what we're saying, is the administrative burden on this program is far excessive from what you would see from other programs. But just to paint the picture of some of that administrative burden, we are now going to have to modify the LEP, which takes staff time, which takes council time, it takes review time. That's not a function that is covered through the grant, but it's a necessary function to be able to administer this program. It's going to involve extensive communications with the state. We've modified the LEP how many times now? 4?
4 or 5.
Yeah. So every time we change even a little, if you recall, we had to come back just a month or two ago, make a very minimal modification to that LEP to be able to effectuate the payment of property taxes. And that was a significant burden on staff time to do those communications with the state and to get those modifications in a way that was appropriate for the state, but met the cultivators' needs and got them into the program in the way that your board had intended. So that is exactly what we are trying to say here, is that the administrative function on this program is extensive. We all agree that this is a critical funding source for the cannabis industry. Should your board want to continue to provide that support to the cannabis industry, we are here to effectuate your board's order, but it's going to take more general fund. And that's why I was just trying to let your board know ahead of time to anticipate that in your decision-making process.
Supervisor Wilson?
And so there's the unfunded administrative costs at the front end and the back end, but in the middle, that's still capped at 10% or something like that, right?
Of the state funding.
Of the state funding, and we have seen it be more than that.
Significantly more, yes.
Significantly more than that. Yeah. So it's not just the two ends of it that cost money, it's also within the administration in the middle. Part of that has been because people have applied, they haven't quite known what they wanted to use the money for necessarily. It's kind of jumped around this, that, and the other. And then the projects are somewhat small relative to the amount of work that has to be done. So it's just a very, very inefficient way to distribute funds in so many ways. And I'm not saying you guys are being inefficient. It's just the system is inefficient. It's just set up that way for whatever reason. We didn't make up the rules. So it kind of comes back to if we were to apply for these funds and still limit it to just the Measure S, like we would still have the upfront money, still have the back money, still probably maybe be able to pull it off under the 10% within the middle if that's all it was doing. Would there still be Measure S need in that timing? Because we have suspended Measure S, so would we still have that? So there would be still. Do you think we would have that amount of money, $500,000, $600,000 of Measure S still hanging out there?
In the queue right now for the folks who were eligible without calculating some of the folks who are later in the queue, and as far as prior awards, there's something like $5.5 million of Measure S outstanding amongst everyone in the past due obligations, not the current.
Okay, so we could look at it that way. We'd be like, well, we are willing to throw, I mean, not throw, but expend $100,000 plus another maybe $200,000 to recoup $400,000 of Measure S in your time. I mean, I'm just saying, like, if we kept it kept it at Measure S without
it would be
veering.
challenging. And
Okay.
I'm still concerned about the overrun of expenditures outside of the period of performance.
Okay.
I think that it's more manageable than if we were to keep it with all of the current service items.
Okay,
and
so if we
other
just pared it down to the most simplest thing, you're still concerned as to whether or not the investment that we make in it will actually be recouped.
Yeah.
Wow. Okay, that is that's sobering to me, and speaks to a system that again we did not create and is challenging for a lot of people. I mean. I don't know. I'm not convinced that it's. Well, okay. Would it be break even? Because that's really the question. And if it is break even, then
With the direction of the grant going to Measure S, it does come directly back to the county. And while Measure S is suspended this current year, the discussion is coming back in 2 month to this board what to do with Measure S. And the board has flip-flopped from suspended to reinstate 10% to suspended, so forth and so on. You have a current Measure S coming due. The bills are going to, like I said, be sent out for last year's growing season to every cultivator that cultivated. So you still have a lot of Measure S out there, current and past due, with a determination of suspending, revocating all of those permits December 31st that haven't paid Measure S. So you're going to have a lot of farms dropping, I would anticipate. I still think that the program is valuable, and while it's going to cost the county $150,000, what you're getting back is exceeding that through the Measure S, if that's the direction of the board. Supervisor Arroyo.
Yeah, I mean, I'm inclined to keep doing it despite the burden, and I know that it's, probably not the most rewarding administrative work to do. And, I think we've heard pretty loudly from the community that this is something they really have a lot of need and desire for. So if it's, even if we just slightly more than, quote, break even, I think that's also not necessarily factoring in the impact that this has on the small business community that's taking advantage of this. And, from what we've heard in testimony in the chambers here, it sounds like for some people who are a bit behind and have this kind of last opportunity to utilize some of these funds potentially to catch up, it could be what makes or breaks them. So I'm inclined to keep doing it. I hear pretty clearly that it's a burden administratively, and it is sort of rare that you have a grant program that can help community members pay a county voter approved tax. It's a quite unique circumstance that I think I'd like to see us kind of bridge that gap for people if we can. And I'm cognizant of it being a difficult investment to make when some of that the certainty about that industry and how what position people will be in is a little uncertain. But it doesn't sound like the recipients could receive the funds and then there's not a way for them to receive the funds and then renege on the payment, right?
If we're doing the Measure S, we actually remit payment directly to the Treasury Tax Collector
Exactly.
via journal to everyone. I do want to quickly just advocate for those who are past due.
Sure.
Most of these folks are having a hard time, and everyone's having to make unique decisions on how they're managing their finances. No one is doing amazing, so some folks are neglecting Measure S, some folks are neglecting property taxes, other folks are neglecting expenses on credit cards. So I think another way to look at it is, rather than decide whether or not you pay the current tax bills or the past tax bills, if you just prioritized it to Measure S exclusively, work down the queue, pay the past due first, but then pay up to whatever they have left current, that still keeps it relatively simple for our administration of the program. And
I'm personally a fan of that. But the question about the reapplication, I think, is still hanging in the air. But I don't, doubt that we'll continue to have, at least for this coming fiscal year, because our current decision about Measure S is still going to be for the future. And this year, what I'm saying is, I guess it makes sense to me to apply for one more cycle of this, given that, the timing is such that I think it could apply to this year's Measure S taxes. And it's sort of a unique opportunity for us as a county to recoup some of those losses, even though there's an administrative cost associated with it.
Sorry, can I ask, if you work yourself down in the queue and nobody owes past due Measure S taxes, and their current S taxes are, say, because it's 10%, so if it's a half an acre, it's $2,300. So if their amount exceeds that, where does the rest of that money go that they're awarded?
Any funding that's awarded beyond what they received would just go to other folks in the queue.
So
if we're just focused on the Measure S, we wouldn't be holding deposits for folks for a period of time.
So
We'd have to be during the period of
I
performance.
get that. So we currently opened it up to land taxes as well, right?
Property taxes?
Property taxes.
Mhm.
And so could that be a portion of, so if you get, I don't know, Jane Doe that owes $2,200 in Measure S, and her property tax on her cultivation site, she has a past due of that.
The
And
problem we ran into...
can I finish, please? And the awardee, say, was $10,000 or whatever the award amount was, then could her property taxes be paid and her Measure S?
Yes, the problem we ran into is that we can't make direct payments for partial years. So most recently, when we brought back the modification to make property tax payments, we had to make those payments directly to the individuals, trusting that they were then paying the Treasury Tax Collector. So there's still going to be monitoring required at the end of that. There's additional contracting costs. So it does get a little bit more expensive if we're dealing with the property taxes as well. Not significantly to a huge degree, but impactful enough that it would be challenging for us compared to the Measure S, which would be relatively simple.
I mean, I would still like, if the cultivator was awarded $10,000, I would like for them to have the opportunity to utilize that to benefit that farm. And if they owe taxes, land taxes on that farm, like you said, they're making decisions. Pay a credit card, pay a land tax, pay a Measure S, buy clones. Help me understand that, Peggy.
So one of the most administratively heavy parts of this program is those direct payments to the cultivators, because we are required then to do follow-up documentation of how that funding was spent, ensure it aligns with the budget that they provided, and even the mechanics of making that direct payment work is, of course, burdensome on staff. And so part of the reason for requesting potentially just doing Measure S is that's a very straightforward, simple internal process, whereas the direct payments to a participant, while we understand impactful, is the part that makes this very administratively burdensome.
So you said that you can't pay land taxes if there's a past due amount?
No, we can't make partial payments. So if there's back due taxes, we have to pay the full year. We can't pay a portion of the year. So, and that was the problem we were having with most of the folks, is they had enough funding to pay part of their tax bill, but not the entirety of it. So we couldn't issue direct payment to the Treasury Tax Collector.
Okay, so could we say that if that amount can suffice without giving direct payment to the cultivator, that we could qualify them that way, that you can make the direct payment to the tax treasurer? How hard would that be?
I don't know if I have a good answer for how equitable it would be. Because we would have to really reevaluate everybody in the queue.
Well, equitably, to get into a payment program, you have to have 20%, and then you have to, so.
You have to pay your current year and then those
Correct.
prior years.
Correct. It seems like you could, if they qualify, and you could make that direct payment to the tax treasurer.
The payment plan requirement was removed in the most
No,
recent LEP.
so say they owe $1,800 in Measure S, and so you pay that directly. And then they owe, and so they were awarded $10,000, and you make the $1,800 payment for Measure S, and then they owe $5,000 to clear their property tax. So they're within, and so they were within their awardee amount. And then you have, another guy over here that owes $2,000 to Measure S, so you pay that, but he owes $50,000 to taxes, so he doesn't qualify for the land tax on the cultivating site. Do you see what I'm saying? It'll probably be too administrative heavily, right?
I'm a little concerned about how much admin time we'd have to spend on it, but.
That conversation alone was a good example of how this gets administratively
Yeah,
burdensome. But I do believe Jessica can address your question.
Okay.
I just wanted to clarify, we need to confirm with the treasurer tax collector, but it's my understanding that we cannot pay property taxes by journal at all. So we cannot internally pay property taxes at all.
It wouldn't matter.
Yeah.
Okay.
Sorry, can we pay Measure S though? Okay. It's like, wait a minute.
And we can get the money to the cultivator who can pay their taxes. So it's not to say that what you're proposing, Supervisor Bushnell, is not possible. It is. It's just more of an administrative oversight.
I would just, if they're awarded a certain amount and they have, so if in the queue they were awarded 10,000, but their Measure S is only X, and that they could clear their property tax on that cultivation site with the rest of the monies that they were awarded, would like for that opportunity to happen for them. I understand it sounds heavily burdensome. It's not anything we haven't done in the past.
No, I think if we included Measure S and property taxes and just held them equal, that we could get through the administrative burden fairly simply.
Then I would be a proponent to that, if the motion maker is going to include that.
Would there be a priority of payment for one over the other?
I think both are just as important, right? I would prioritize Measure S too, because they're going to lose their cultivation license if they don't. But I would go Measure S first, then property tax if they have amount that's left over. But it needs to be in the motion, I think.
I would say, though, that there is a minimum threshold of administrative cost to anything you do. And if it's $500 in back property tax is going to cost you guys $1,500 to administer, this is not working out very well. And we're in a situation where I don't know, it's not making sense. It's a little bit of a hamster wheel, I feel like. But if that's the way the board wants to do it, for me, I would just stick with Measure Z. Sorry, gosh, it's what time is it? It's 4:30. It's been here all day. So this would be to authorize the county administrator to accept the CEG for fiscal year 2024-25, prioritize remove the 12 programs and prioritize Measure Z repayments, Measure S, sorry.
And
They're just blurring together those two shapes in my head, and then provide to direction to staff, which is basically to apply for this program, which I personally am not in favor of and may not vote for, but I want to get the motion out there because I hear what the other folks are saying. To apply for this funding for Measure S and property tax for the next fiscal year, and I guess that's the motion. So.
I'll second the motion that you're not sure you're going to vote yes on. That's an interesting way to do it. Okay.
He does it all the time. So can I clarify on that motion that it would also include property taxes if the awardee, that's what you're hearing in his motion? Okay.
On the renewal, not on this year's, because I think this year's, we have to prioritize measure.
Can I ask you to include that? Because if an awardee is awarded $10,000, and
Okay.
like I just said that, if they're only getting $1,800, they have more money. It would be passed to another person, but if they could pay their land taxes with it on their cultivation site, they've earned that. They were awarded X amount of money.
I hear you. So,
And as we're talking about the administrative function around this, modifying the LEP once versus coming back with a renewal and modifying it again
Okay.
adds to that.
okay, so yeah, so having both of those, but prioritizing Measure S and then going to property tax after that. That sounds like the boards. That's what they want. So,
With past due being paid over current.
Yes.
yes, that's the motion. If there's a second.
I seconded it. We're good.
Push your button, Mike.
Motion carries 3-1 with an absent vote as well.
Thank you, and we're adjourned.